Yes.
Item 2 and 3.
Hmm.
So it's a part and major.
Yes.
The quotation I am seeking.
Uh,
Some hearing date.
You have
Yes.
informed the other side.
Yes. He
Get you, buddy.
take it there after 5th.
After 5th.
Right.
10th or 12th? Take it.
12.
12th.
Problem.
But I beg to mention item number 22.
Just a
The
minute.
English consists of out of station alert. The English consists of out of station alert due to some family problem alert.
Item?
Generally taken on the next week.
Item number
22.
22.
My lord.
22.
Mr.
Yes, the government was required to file an additional affidavit in opposition. We'll take up the matter when it reaches. We will not pass any adverse orders.
Problem.
Yes.
Yesterday I made mention for taking one.
There is a senior bench
I don't think.
for mention.
Asked me to
Yes.
verify. Your lordship asked
I did that,
to verify.
but I have been informed that there is a senior bench.
Right.
Now, if that has been, if the matter is a make a request to the registry or mention it before the senior bench, we cannot. Yes,
Item number.
The other side, I have to mention item number 31.
31. Yes,
We are awaiting there.
I appear, my lord.
pleadings were complete.
Yes, pleadings are complete, my lord. I
Ah.
do not know what further instruction.
What further instructions do you need?
Not to record certain documents by way of filing reply affidavit.
Yes,
We have sent it to the other branch. We are taking certain instruction.
I think we should let the matter reach.
Let it reach, my lord.
Let it reach.
Let it.
We will not do anything adverse in case the documents are required, but if this is, if we do not need the documents or any verification of it for disposing the matter, why should we keep giving time?
My humble submission, let the matter reach.
Let the matter reach, we'll see if it requires any clarification from your side on the documents that now he is producing. You will have the opportunity.
Okay.
Yes, yes, sir.
Item number 8.
8,
That I will be listed after 2 weeks,
2019, we'll have to take it up.
after 5.
No, we'll take it up today. We'll see why we should give you time. It is 2019 matter.
Also, Arshad Bapachogo, he is having some eye problem.
I understand. We'll pass an order when we reach the item. That is the only thing. Because prior to 2022, we are not giving dates on mention. We need to pass some orders in it. Okay.
Item 52, my lord.
52, yes.
I have instructions not to press.
Cumulative effect to increments with cumulative effect. Okay. Ms. So-and-so, learned counsel appearing for the BTC has submitted that they have filed their affidavit in opposition with an advance copy to the learned counsel for the petitioner. The learned counsel for the petitioner seeks a short accommodation to file a reply if necessitated, full stop. Accordingly, list this case on
Second week of March 18.
2nd week of March. Did you? 11th of March.
May I please, your lordship?
Yes.
Item number 44, my lord.
Huh?
I need accommodation for the day only, my lord. Item 44, my lord.
It's a fixed matter.
Today, I have some personal difficulty.
Learned, Mr. So-and-so, learned counsel appearing for the petitioner has submitted that he requires an accommodation for the day, full stop. Accordingly, no, the prayer is not objected to by the counsel for the respondents. Accordingly, list this matter again on, pick a date,
Any date
Take it.
next week, my lord.
next week. Silo put kita ase.
6.
The case is otherwise ready for.
My lord, respondent side is going to file their affidavit today itself. They have
Okay.
informed me.
You are appearing, sir? No.
No, my lord.
ठीक है.
Oblige.
May I please, your lordship? Lordship, may I beg to mention item number 15, lordship.
15.
15, 1-5, lordship.
1-5.
Last
Yes.
petition, honorable court was directed to the NF Railway to submit an inquiry report to the petitioner. On that report, petitioner will collect the instructions. But learned counsel has not furnished the inquiry report, lord.
And let the matter reach, we'll see. Let the matter reach, we'll have a copy delivered in the court itself. If we give a time today, nothing will happen.
Yes.
Let the matter reach. Yes. It is that matter, no, where the person died while on duty, whether he's
Yes,
supposed to
yes,
get
Lordship.
compensation or not.
Yes, yes.
Banks to matter of the 2000 of 2023, it
Hmm.
is listed in the part two hearing list.
Hmm.
So if you have a time permit, can it be taken up in part two list?
Part 2 list আছে নেকি আকৌ বেলেগ এখন?
So the usual daily list.
Huh?
Daily list.
It's in the daily list. No, is there a part 2 list actually?
Part two list is there, notice.
Hmm.
If any urgent matter is there, that may be mentioned before respective fans.
Oh, that is given there. Item number?
Item number 16 of part two list. Fans
Item number 16 of part 2 list. Now, are we taking up the part 2 list? The bench is also divided. Who takes it up?
But there is written that if any urgent matter is there, that may mention.
No, part two list concern.
Part two hearing list. Fans.
Huh? You see, our list does not show that we are supposed to take up the part 2 list. Kindly consult the list. If there is some bench which is marked to take up the part 2 list, the mention has to be made there. Once it comes in the main list and comes before us, we'll take it up. To bring it, the part 2 list can be only taken up by the bench which is marked it.
May I please?
Yes.
Lordship, I beg to mention item number 42, Lordship. In fact,
42.
Lordship, I'm praying for adjournment of this matter, Lordship. Senior having some personal difficulties, Lordship, today.
This is a review petition.
Lordship.
Okay. Any interim operating or something?
Hmm.
Learned Counsel appearing for the petitioner has prayed for an accommodation
Next week,
today. List this matter again on
next week.
4th at the request of the Learned Counsel for the petitioner. It's done. Yes. Hmm. Hmm. Yes.
Item number 57, Lordship.
57. Yes.
We have filed a rejoinder yesterday,
Ah,
so which may be called for. Applied.
May I
Hmm.
please, your Lordship?
mhm.
Lordship, this is a proxy matter, Lordship. Notice may be issued upon respondent number 2, Lordship. And
Why
Lordship,
is it before us?
Lordship, it was one withdrawn, Lordship.
Huh?
Once withdrawn, Lordship.
It was once withdrawn.
Yes, Lordship. Lordship, bail for co-accused is fixed on Lordship, second, on second.
2nd of February.
So that may,
Heard Mr. So-and-so Learned Counsel, also heard Mr. Sharma Learned Counsel, Learned APP. The Learned Counsel for the petitioner submits that a bail petition for the co-accused
BA 69 of 20.
being BA 69
Yes, Lordship.
of 2026 is listed on the 2nd of February, full stop. List this BA also along with the aforesaid case, full stop. In the meantime, the notice be issued to the respondent number
2, Lordship.
through in accordance with the prevalent notification.
Deeply obliged.
Yes.
Supplementary item 55.
Only 2 days time may be granted to.
Eh?
2 days time.
What was the
Upon response file.
yes, education who appears for the elementary education? No, sorry, secondary education.
Secondary degree.
After some time. Let us see why they are not passing an order. What is
Yeah.
troubling them? Do we need to wait for the notice or not? Yes.
Matter has although matter has been already been heard by the deputy commissioner.
We'll get the order. You can challenge the order if it goes against you. This is item 4.
Last occasion, my lord, by order dated 5/1/2026. Your lordship, go to it.
Divisional Screening Committee. Can we take up this matter? We were handling all the Dhemaji and other screening committee matters.
My lord,
Other screening committee matters we were acquainted with when we were on the other side.
different issue
It is
because of.
different, we can take it up.
Yes, my lord.
Okay, yes.
Here also,
Currently,
the petitioner had appeared before the screening committee.
Yes,
But the outcome of the screening committee.
yes. We will, since the matter is of 2017, kindly have your, one of your efficient and well-conversant officers present before this court on Monday, along with the result of the screening committee. Can it be done? We are 9 years into the matter.
Lordship.
Is it not? Huh? When? No, that was what was done on 5/1/2026. That is what was done on 24/7/2025. That is what was done on 26/2025. Then that is what was done on 12/2/2024. That is what was done on 4/8/2021. Should we go on? Monday.
At two,
Monday
at two.
with a responsible officer with or without instructions. Or today at 2 with the instruction. Only the council will do at 2. No problem.
Instruction, I will communicate today. In fact, my learned colleague, Mr. Ajay Khattar,
No, regularly this practice is going on.
communicated. And once more, we will remind today, Lordship, but fix it on Monday.
Monday with instructions and with the officer.
My lord, that, as per instruction, that lady till today she is doing work, my lord. And my lord, similar selected persons are given, all are, my lord, given tutor, but that lady is left out.
Absence of instructions for the last 9 years, we are not taking any lenient view. I'm sorry. Heard Mr. N. Bora, Learned Counsel appearing for the petitioner. Notice in this case was issued on 11/1/2017. On 27/2/2017, a reference, this court recorded a reference to some re-verification process and allowed the counsel for the education department to obtain concrete instruction in the matter. On 10/3/2017, this court had directed that the respondent would positively file an affidavit stating the status of the verification.
Last time, people said, you can affidavit. Island 2007.
Yes, sir, everything.
Now that the outcome of the.
Learned counsel for the respondent has submitted that for the said order, an affidavit was filed on 11/May 2017 by the then director of the department. On 4/2/2019, the standing council was requested to ascertain the present position as to whether the name of the petitioner figures in the list pursuant to the verification made by the Divisional Screening Committee, Central Assam Division, Tejpur, full stop. For ascertaining the said position, time was again granted on 19/3/2019. Full stop. When the result was not made known to the court as required by the earlier orders, on 20/11/2020, this court required the respondents to submit on the next date as to why appropriate orders should not be passed requiring the authorities at least to inform the court about the outcome of the enquiry made against the petitioner. On 21/1/2021, another order was passed requiring the respondents to submit the outcome of the re-verification report. By order dated 4/8/2021, this court observed that this court recorded a submission made by the Standing Counsel for the department that the petitioner on two different occasions had made two different statements before the inquiry committee, and therefore a final decision was yet awaited. Full stop. The matter was next listed on 12/2/2024. Comma, observing that the Standing Counsel were yet to receive the instructions sought for. Time for 2 weeks was granted, making it clear that no further adjournment shall be granted on the next date fixed. Full stop. Showing leniency, the respondents were again granted time for 3 weeks on 26/2025, comma, 1 week by the order dated 24/7/2025. Full stop. By the order dated 5/1/2026. The matter was required to be listed today. Full stop. Unfortunately, today also the Learned Standing Counsel has been constrained to make a prayer for an accommodation since instructions are yet awaited. List this matter again on the 2nd of February 2026, on which date the director shall depute a responsible officer to appear before this court with the instructions which with the information which was called for by this court by the previous orders. Full stop. In case the information is not available, comma, the officer deputed to be present in the court shall inform this court the reasons as to why the information has not been made available to the court for the last 6 years. List again on the 2nd of February 2026.
My lord, my prayer is that instead of director, commissioner may be read this record, because of director,
No,
there
no,
is
I'm
a
not asking-
scanning committee report.
I am not asking the director to appear. I'm asking the director to depute a responsible person.
So
Okay, make it the secretary. Don't say the director, the secretary.
Secretary.
Comma. School education shall depute in a responsible officer.
Much less.
Let them, for the last 9 years, if they have not been able to find it out. It is one name, yes or no. He did not work. The entire case changes. He has worked, the entire case changes. Not letting a person know. Somewhere at the top, you also had one sentence. The Learned Counsel for the petitioner has submitted that the petitioner continues to serve in the school, although
Till-
she has not been paid.
Till today.
She has not been paid
That-
any
but-
salary till today.
Much
Continue, we have
less.
said continues.
Yes, sir. Much less.
List before a bench without me.
Hardship.
We remember these names. We will not take it up.
Always.
5/8. Yes, sir. Item 8. You were required to file a reply.
Yes, my lord, there is simple modification is required because respondent number 7
Saying? That the, one of the petitioners had expired.
Yes, my lord.
Have you taken steps to have the
Yes,
name
sir, that's why
deleted
I'm
or
going to modify
substituted?
and already, affidavit is already been ready. Actually, just a simple modification is required. We are going to file within a day or two.
You have to
And the
see,
late-
sir, this was an information of 26th of March 2025.
Yes,
The court faces
section,
lack of the,
my lord, actually senior counsel, he is having some eye problem.
I
He is under
understand.
observation.
From March onwards, from March 2025.
Let the matter may kindly be listed after 5th of February in any day,
On the 5th of February or any other date.
after 5th of February.
Mr. So-and-so learned counsel appearing for the petitioner has submitted that steps are being taken for steps are being taken for moving an application which has arisen due to the respondent number 7 having expired in the meantime, full stop. Oh, respondent number 7 struck off. Sorry, you cut it out. Cut it out.
His name already been extract off.
My mistake. I saw an earlier order. Cut out the entire order. See, Mr. So-and-so learned counsel appearing for the petitioner has prayed for an accommodation to be allowed to file the affidavit and reply. Full stop. You were saying? Okay, cut out the entire order. List before a bench without me. No, you said a communication. I thought some communication from the department to you.
Yes.
Sorry.
Item 9. Regarding item 9.
Ah.
Then police record losses. One is time is granted.
Has it been traced? Why do we need the records? Why do we need the records? Tell us that. No. What we are saying is the issue is that an NOC was issued. Later on, the same person who issues the NOC sits in the selection board and says, no, we will not accept the NOC. He's the person who issues it. So the best relief that the petitioner can have is he faces the interview. No other relief. He will face the interview if we allow the writ petition. If we dismiss the writ petition, nothing remains. Why do you need the records?
Because of court order, I think.
No, court order. Why did the court order so? That is what I'm asking you. Yes, sir. Do we need the records?
My lord, in this case, actually records are not required.
That is what we were thinking when we were going through the.
Is only thing regarding one aspect,
Yes, the NOC,
Yes.
whether.
nothing else.
Show us the NOC.
My lord, page 33,
Yes.
Annex
Inspector
12.
of school, yes.
What was their ground? This NOC you have given, like me. This NOC you have given along with your application. That is okay. But we did not receive through proper channel from the concerned IS. Unless and until we get that, you cannot be a candidate. But before that, my candidature was accepted. I sat in the thing, and your lordship is aware, in respect of earlier guidelines, 5 marks were given. 5 marks in the categorized, 5 marks were given for the assessing the person's individuality as far as his teaching and all this. Those were also done. Suddenly, one person raised question, no, we did not receive his NSC. The crux of the matter is that earlier 5 marks were with the selection body. In this case, my lord, this gentleman, very unfortunate, in 8 of the institutions, he came second. Out of that 5, if I get 0.5, the person who is selected, he gets 4.5. Over here in this case, this is primarily my plea. If you give me 0, still I become number 1. So you had only one option to
Cancel the candidate.
cancel the candidature. You have done that.
Yes, who
If
has
your-
cancelled it?
your
Who
lordship
appears
looks
for
at-
the selection committee?
If your lordship looks at the first order,
Ah, yes, we saw,
Yes.
we have gone through the orders. We did not
that
go
was
to
the only case, my lord.
Ah, yes. Yes. Tell us, why do we need the records? Show us the law that it has to come through the issuing authority to you. Where is that law? Who is the selection committee? Please come. We are allowing the writ petition. We are allowing the writ petition.
My lord.
From 2020,
Yes, my lord.
an institution is without a teacher because of a stay. Is it?
My lord.
There is a stay order operating?
Yes, there is a.
None of the respondents interested in getting it vacated? Anybody has filed a stay vacating? Yes? You are the selected candidate.
I am
You are for the
For the
college and you are for the you are for whom?
for the respondent number 8, private.
Private respondent, forget it. The college, tell us. You are the person who was finally selected if he is not selected.
Yes.
College.
Filed the affidavit,
Huh?
they filed the affidavit,
Yes. Where is it?
and
My lord, before only your lordship goes through that, I would only want to say one thing I would like to add.
Ah,
Every minute, like when my candidature was said to be rejected, I
Hmm.
immediately made a email to the director
ah.
on that day itself through mail, then again gave the hard copy. So that way I informed the authorities that this is going on. And what is the reason? I said that it's only because of that NOC. But NOC ultimately there is a RTI. In RTI they said the NOC was received.
Did you cross the age
Yes, now no. On that day, no.
on the
They
date
are
of
saying
recommendation?
no. They subsequently took the plea that I crossed the age by 1 day.
When?
But if we take
On the
that,
date of?
huh?
On the date of?
on the date of interview, no, not on the date of interview, while filing the affidavit. But I have the earlier proceeding where the question of age was not there. Subsequently, I don't know, my lord, how it happened. But actually, I was last cut-off date on that day. If your lordship leaves either of the day of the entry or the last date.
You were serving as what?
I am,
You were working somewhere
yes, assistant teacher,
in a?
Jumnamukh High Secondary School.
So the
as a graduate teacher.
inspector of schools at that point of time was the appointing authority.
No.
Yes.
Yes, he was the appointing authority.
Yes, what do you want to show from here?
circular regarding
This is for the post of assistant professor. This is for the post of assistant professor of what?
Botany
Botany in?
in Sri
College, Hailakandi.
SS College, Hailakandi.
What is the? How is the age to be seen? By which rule?
My lord, that page, it is there in advertisement, my lord.
Age as on?
Page 28.
page 28.
Page 28
Hmm.
of my writ petition.
So you should have been 38 years as on the first day of the year in which the advertisement is issued.
Yes, my lord.
What is your date of birth?
My date of birth is 31st 12,
31
31st 12, 1977.
Hmm.
So 38 years plus I get the 3 years for OBC, 41 years. On that day, my lord, exactly I was 41 years living either of the day or the day of the first day or the last day as per section 5. But that plea was not there initially. It was,
Need not be. If you do not satisfy the age of the age as per the advertisement, everything goes.
no, I satisfy, I'm within the age.
How?
My lord, it has to be 41 years. That is on the first day of the year.
Should
So
not.
I was 41 years exactly on that day. My lord, section 9 of the General Clauses Act will
If
come in.
Will you be 41 years on the 1st of January? No.
1st of January, I become, if we take
41
31,
years,
if we take
41 years one day.
if we take 31,
No, no.
3177,
No, no. On a general conception, when I ask you how many years are you old, you say it on your birthday that today I'm so many years old.
My
Is it
lord.
not? I think you're 41 years one day.
one day. What my lord is saying, 41 years, one day. That's, my lord, suppose I take 31/12/1977 to 1/1/2019.
Hmm.
That as per the advertisement, I become 38 years one day, my lord.
Hmm.
But section 9 of the General Clauses Act will come in, my lord. Either you leave the
In
31st of the
calculating
first.
the age, no.
Yes,
No, no.
yes. 9 is exactly for the age only. General Clauses Act 9 is exactly for the age. Either you take the one of the day, either you take the first day or the last day. If we leave out 31st,
First
That-
day, I did not get it. First day or last day for calculating?
for calculating the age, suppose
Ah.
you have from this date to this date.
Hmm.
Suppose from 1 to 31, if you take a particular period, so exact days you will get either
You are
take
born on 31st of December 1977.
1977.
So on 1st of January, you are one day old.
Yes, madam.
On 31st of December, you are 1 year old.
Yes, madam.
On 1st of January of 1979, you are 1 year, 1 day old.
Yes.
So on the first day of 19, you are 41 years, 1 day old.
Yes.
Then
What I'm saying, my lord, now the question is, suppose my lord has taken this their plea of age. That
it is not about their
No,
plea,
what I'm
sir.
saying,
It is not about
if
their
it is
plea.
one day, then my lord.
Suppose we allow your writ petition, if we send it back, then the next question, once they find you ineligible on a particular ground, they will not give all the other grounds. They will say you are ineligible in this, go. Suppose we say that no, that was a wrong, then they will have to look into the other eligibility
Yes.
factors.
I understand.
We will not look, they will not look into all
you-
the factors at the same time.
To be pleased to see section 9 of the General Clauses Act once, my lord.
Yes, Dioksun. Where is it? আছে নেকি? Good, good. General clauses এখন আছে নেকি? দিয়ক।
বই দরকার।
Section 9, did you say, sir?
Section 9.
Huh? Oh. ওটা অদ্ভুত বস্তু কিছু নাই। Hmm? What does the section say? Do you have it before you, sir?
My lord, I'm sorry, I could not, I missed the book.
When would you like to have it? Because we are almost convinced that you are 41 years and 1 day old. That would change the entire perspective. In any central act, starts with any central act. Is this a central act we are dealing with? We are not dealing with a central regulation. It shall be sufficient for the purpose of excluding the first in a series of day or any other period of time to use the word from, and for the purpose of including the last in a series of days or any other period of time to use the word to. How does it relate to the calculation of an age? A person should be 38 years as on. This is not a central act. This is not a central regulation, number one. Number two, it does not use the word from and to. It says you should be 38 years. But one thing is troubling us in this advertisement. You say 38 years. You do not say not above 38 years. He should be 38 years. He was 41 years 1 day. Where is the problem?
Whatever.
Where is the problem as per the advertisement? Show us.
Whatever written in the advertisement will my lord subject to the guidelines also.
What is the guideline?
Guideline, my lord, that I have given, my lord, it says
What?
that
Should not be more than 41 years anywhere written here. Where is it written?
30 years, my lord, it is for the general candidate.
Where is it?
The guideline is 23/1/2000.
Show us that sentence.
First paragraph, my lord. It has come to the light of
Ah,
the candidates already crossed the limit of the. And the connected guidelines are with the department, my lord, they can produce. My lord.
hmm.
They have their own guidelines with regard to age. My lord.
Yes, sir, unless you convince us that 41 years was in a lighter note. The maximum age is 41 years for an OBC category candidate. But unless you can show us that, we will have to take it as 41 years on 1/1/2019.
The 41, we get.
On that ground.
No, we get 38 plus 3 years benefit of OBC.
So 41, I'm
Yes,
saying
yes.
41.
Yes,
You have to show that it is 41 years as on 1/1.
Yes.
You have to show that your age was 41 years. So this, otherwise with the NOC part, we are wholly satisfied.
my lord, even I have come across a decision of our court where,
Mhm.
where the question of this came,
Hmm.
the General Clauses Act, Section 9 was.
Kindly give it
applicable.
to us. Give
Well,
it to us, show us that we can take you to be 41 years as on 1/1/2019, if I'm not wrong.
That-
If you can show us
That
that,
from and to, that one
not
day.
the from and to, for the age,
No, no. what
just
I'm
for the
saying-
age.
no,
How to
what I'm
calculate
saying,
the age?
Suppose, no, what I'm saying,
We will not go by the General Clauses Act because it talks of to and from. We are required to calculate your age on a particular date. Give us something to show that a person born on 31st of December, be it any date, what I'm just saying is that on 31st of a particular month, will be taken to have completed a particular number of years only on 1st of the next month.
I understand.
Done.
I understand,
Should
but
we
what I'm
argue?
saying that the decision, okay, my lord, I'll get it done.
It was something we had heard from one of our senior friends who's before us. He told us one day. In fact, you told us one day There is nothing new under the sun. There is always a precedent. Get us one, sir.
Sure, my lord.
When can we have it?
Let it be furthered.
When can we have it?
My lord, today,
Give us a date.
as per what the
Till 13th of February. Give us a date till 13th of February. Any day.
after 13th,
Before.
before 13th of February. So let
Any
us
day.
make it on 12th.
Yes, 12th of February. Heard in part. List again on 12th of February at the request of the Learned Council appearing for the parties. You also give us some law that it has to be on the 31st. This way, that way we will do it.
Deeply obliged.
Thank you.
May I please,
Mm.
Lordship?
Mm.
On last occasion, they prayed for time to take instruction because their officers are saying that my case may be considered as a special one, Lordship.
For what?
For,
10,
well,
10.
sorry, extremely sorry, Lordship. I thought 12.
One of the directed after file, academy we have filed on Monday, my lord.
You have filed the affidavit.
My lord, on Monday.
You have received a copy, madam?
Still, we need 2 weeks to file our reply. Plus-
Ms. So-and-so appears for the petitioner. The Learned Council appearing for the respondent department has submitted that the affidavit has been filed on Monday. However, the same is not on record. You have filed your affidavit in opposition. No, you are appearing for the Learned Council for the respondent number 5 has submitted that an affidavit has also been filed on behalf of the said respondent, full stop. He also appears for the respondent number 6, who has however not filed an affidavit, full stop. Learned Council for the petitioner has sought for an accommodation for 2 weeks to file their rejoinder affidavit. Accordingly, lists this matter again on 16, 17, when?
7.
17. 17 to hearing the khali rakha bhal na.
16.
Matter karne.
16.
16th of February 2026 to enable the Learned Council for the petitioner to file the rejoinder affidavit, registry to trace out the affidavit in opposition stated to have been filed by the respondents and tag it with the records. Ms. So-and-so appears for the respondent number 4, who has not filed any affidavit. Should we see? Yes.
May it please your lordship. Lordship, I'm appearing online due to some difficulty.
Just a minute. You are still invisible to us. Just a minute. Yes.
Yes. I apologize, my lord.
It's okay.
My lord, I have been informed that the additional AG would be taking time on this matter.
Okay, let me hear him then. Yes?
I have a- We have some part-
What is the matter about?
My lord, then I may please.
No, shortly, we just want to know
Yes.
how soon we should have it listed.
Yes, my lord, we are 37 inspectors, my lord, who were directly recruited. And we being senior most, by an order of the, without considering departmental proceeding, the private respondent was promoted, which has been stayed by this honorable court, my lord.
It has been stayed.
Yes, my lord. That no, it has been an order has been there where it has been reflected that no coercive action.
There is no stay of the gradation list.
My lord, it is
What was that order?
22/9/2022.
Huh?
22/9/2022 order, my lord.
Respondents are directed not to take any coercive action superseding the petitioner. Where is the stay for a gradation list?
So there was no stay for the gradation list. There was a direct order, my lord, where it has been categorically stated.
Huh? So was that?
That till the next returnable date, respondents are directed not to take any coercive action superseding the petitioners.
Hmm.
So that on 16/11/2022.
Coercive action is one thing and usual process is another thing.
Yes, my lord. So after that,
Yes,
after
when
that,
do you want it then? Okay, let us have it on some other day when we can hear the additional AG also.
yes, my lord.
Arik,
My lord,
Mr. Sharma appears through VC. Full stop. A prayer has been made by on behalf of the learned Additional Advocate General Mr. K. Kuar for an accommodation today. Full stop. Accordingly, list this matter again on
my lord, 19th of February, my lord.
Hmm. When would he be able? He'll be able on 3rd? On the 3rd of February, Mr.
My lord,
Sharma.
my lord, I have some medical emergency in my family. Because of that, my lord, I've been outside at that week. On 19th of February, my lord.
19th of February.
It's a Thursday, my lord.
On which date? On which date the if the matter is on which date if it is not possible to take up the matter in the entirety, the interlocutory application praying for modification of the interim protection granted shall be considered. That will do.
My lord, may I just submit here one? My lord, there was an IA which was listed along with this, which has been disposed of, where there has been a prayer recorded by the respondent that they will not take any action until this final writ petition will be disposed of with superseding the petitioners. And it has been
There is
on
an
the,
IA pending.
yes, that has been disposed of. And then
No,
they
it says
filed
it
this
is
IA
disposed
statement.
of.
Yes,
I
no, my
am
lord, there are two IA. One IA is for state
দুখন IA
vacating.
আছে। এখন disposed এখন pending. Disposed of কি হয়? Just a minute. 189 is there. Provisional gradation list will not be finalized. There was a statement made. Yes.
Yes, my lord, there was a statement made, the provisional
And-
gradation.
Mr. Bora? Yes, ma'am. I think this application is uncalled for. The additional AG has made a statement that till disposal of the writ petition, the provisional gradation list will not be finalized. Then how can you have the same department, the same state respondent filing an application saying, please modify the other order? This cannot be entered in this IA. There was a statement made on behalf of the additional AG on
28 to 24.
IA 189 of 2024 that we will not finalize the provisional gradation list. How can there be a sudden change? That is what, yes. On the 13th of February, where we had set a headline to কি করলো কোকসন এবার? And on which date an attempt would be made to consider the matter in the entirety, since the respondents have expressed urgency in the matter, full stop, the matter relates to finalization of the gradation list and the seniority of the petitioner concerned. On
My lord.
13th, please be prepared.
My lord, 19th, my lord, I prayed for 19th. 19th, my lord. 13th is a Friday anyways, my lord.
We work harder on some days. Yes, 19th.
Much obliged, my lord.
19th, we'll have it on 19th. Interim orders would continue.
Much obliged.
Interim orders passed earlier shall continue. You don't want that. Okay.
My lord,
He does not want that. No.
It's fine.
Yes.
Much obliged.
কিমান এইটো 12 yes madam
Lordship, on last occasion, they prayed for time to take instruction.
yes sir the pensionary benefits huh
Regarding from CPF. Cut off date is 14th May 2016. After that, no application.
no
No application has been entered in.
yes now here we have a special case now here we have a special situation
Yes.
the person was under suspension during that period you would not like him to enter your office or have anything to do with your office till the time he is reinstated in service this opportunity came when he was under suspension the moment his suspension is removed the suspension goes and he is allowed to join back without a penalty what happens to the earlier period as if he was in regular service
Regular.
right so now if he has to get that benefit of a continuity of service he has to get all the opportunities which the other people had
Yes.
including an opportunity to opt for CPF GPF whatever
Without, as per instruction. without-
Ah.
The suspended employee is also an employee
yes
and his status is regular employee.
yes
Though he has been suspended.
yes
So, he should have opted for that.
one communication from you to him that this is a scheme undergoing you are under suspension please opt a suspended employee will not be attending office except giving an attendance in the morning and in the evening
Yes.
he will not be going through office files he will not be allowed to attend anything in the office he's suspended hanging in the air
But,
how do you say that he was supposed to put it in
free to opt for that.
no
So
we are disposing it off
If there is any.
we are disposing it off the application made by the petitioner from CPF to GPF
Yeah.
will be considered by the university without reference to the date on which his application was made since he was under suspension at that period of time.
Because,
Make a consideration if he is otherwise eligible, he is required to submit his CPF contribution to you so that it can be converted to a GPF and his pension starts, do it. If he is not eligible, throw him out.
I'll mirror.
Huh? We'll do. We are hearing it finally, sir. Trust us. We are ready, sir. I'm sorry.
Their officers are also admitting, my lords, Lordship.
We are not causing any delay because this is of 2016,
A short date.
2022.
17, I'm suffering, Lordship.
You retired in 17.
Lordship. But I'm
True.
teaching them.
And we are taking it up for disposal in 2025.
Very short date by for final hearing.
We don't have then, we don't get to dispose anything on a particular day. Everybody is taking time. Tomorrow, day after, next week. Ah.
But I'm not
Nothing.
ready for final hearing today.
Ah.
So, Miller, at least Miller,
At 2?
tomorrow or Miller the next week.
Not tomorrow, we'll have it on Friday. Just show us.
I have some difficulty finding that on Monday or.
Monday কেটা হল কি? চাইছে নেকি?
Nothing else.
Civil case এটা দেখাই আছে। Refresh কৰিব লাগিব নেকি? হা? Anyway, Monday did you? At the request of Mr. P.J. Fukan, Learned Standing Council, Guwahati University, place this matter again on the 2nd of February 2026. Full stop. The submissions of the Learned Council for the petitioner has been heard. The Learned Council for the respondents are requested to be prepared for a disposal on 2nd of February. Learned counsels for the parties, respondent nominative for the parties are requested to be prepared for disposal. Yes. Mediation fail.
May it please, my lord. Matter pertaining to regularization of the petitioner's service, my lord.
Ah.
Regularization of the petitioner's service, my lord. They were initially appointed in the year 2001, my lord.
Just a
as
minute,
OBBT.
just a minute, just a minute. What happened in the mediation? Nothing. 7-8.
Yes, sir.
You are required to appear before mediation. What happened to it?
It's item number 13, Your Lordship, I believe.
I don't know.
14.
13, 1, 3,
Yes, Lordship,
13.
I am
Sorry,
referring
sorry,
to
my
13.
14.
Lordship, in this matter.
We thought there would be some delay, but we see an urgency in taking up matters. Yes.
My humble prayer is that Lordship, mediation has failed, Your Lordship.
Hmm.
A hearing date may be fixed, Your Lordship.
We can start.
Lordship, this matter regards the pension, Your Lordship,
Just a minute.
whereas in the GMDA.
The
extensive
GMD
hearing is
affidavits
required.
have been filed.
Lordship, all pleadings are complete. Lordship, they
Pleadings are
filed.
complete.
Yes, Lord.
Mr. DJ Das, Learned Counsel, appearing for the petitioner, has submitted that the mediation process has not succeeded,
Yes,
and
Lord.
therefore the matter would require to be adjudicated upon. Learned Counsel for the respondents also state the same. Full stop. The pleadings are have been stated to be completed by both the parties. Accordingly, list this matter for consideration on
Admission hearing, Your Lordship.
when, or for admission hearing on
24th, Your Lordship,
24th of
is February, Lordship.
February, on
it's a hearing
24th of February 2026.
That's what that's for.
Yes, sir.
Yes, my lord. My lord, matter
Your
complete-
reply filed?
Yes, my lord. Pleadings completed, my lord.
They're newly appointed, so.
For whom?
The copies.
For whom?
BTC.
BTC.
Newly appointed, we have the copies of the petition. Humbly pray for your chief to direct the party to provide the petition.
Have the BTC authorities given you any list of the cases in which they are involved? Or will it be a system where every time a matter comes up, someone will stand up to say that we are newly appointed, we have come to know about this case only today? Kindly tell us. Ask for a list from the BTC authorities. You cannot keep granting dates just because they are newly appointed. This we have been hearing from around July. We are newly appointed by the BTC. What is the BTC doing? Huh? I don't know. What is the matter about?
Matter pertaining to regularization of the petitioner service, my lord.
Ah,
Initially, my lord, they were appointed in the year 2001, my lord,
Ah.
OBB scheme, my lord. Then, my lord, their service was cancelled, my lord.
hmm,
Then, my lord, they prefer in writ petition before this honorable High Court, my lord.
hmm.
Then, my lord, some of the petitioners, my lord, filed an IA, my lord, and they withdraw.
From
And I filed
from
an-
that read
yes,
petition.
From that writ petition. Then, my lord, there is a details report, my lord, page 103, my lord. There's a letter, my lord.
Take your seat, sir. We'll see what we can do. Yes.
Page 103, my lord.
Ah, we have seen 101, 102. Yes. Then
In inviting a reference DC letter so and so in the subject cited above, I would like to request you to submit to detailed authentication report and present status of the case as contained in the letter pertaining to select.
persons have been regularized, all who are required to be regularized. Where were you left out?
Yes, my lord. Thereafter, my lord, details report 107, my lord.
Eh?
There is a report in IA which we have withdrawn, my lord, from this 107, my lord. Kindly see, my lord. Detailed report on IA civil number so and so, my lord.
What happened then?
Yes, my lord.
You withdrew from the case. What happened to the case? The case from which you withdrew? Those petitioners got some relief from the court.
I have no information about this. My lord. Because, my lord, we have withdrawn and our matter was, my lord, in executive council matter passed, my lord, that our service should be regularized, my lord. And
So,
that was, my lord, pending before finance department.
ah,
Now finance department did not, my lord, take any action, my lord.
Hmm.
That report was pending before finance, my lord. I have met finance also party.
who appears for the finance department? Does the cause list show finance department?
Yes, my lord.
Huh?
Yes. BTC has filed also one affidavit, my lord.
Who?
BTC, my lord.
BTC affidavit, we'll see, we'll have to take the view of the finance. Regularization will not be
Yes,
without the
page one
finance.
31 there, my lord. No, fine. Page 131, BTC,
Hmm?
BTC's affidavit, my sir.
Hmm?
Page 131, para 12, my lord.
This is item number
14.
14, Mr. Chaliha. They are not supplying you the cause list. Eh? Internet is not working in your office. Ah, where is that amended cost title? Amended cost title filed. Have you supplied copies to the finance?
Yes, my lord.
When? Huh? You are respondent number 14.
14. Later on, my lord, I am.
Do you have a copy of the writ petition?
Not have a copy of.
They are those 7066. There were two batches.
Yes, Lordship.
7066 BTC. Executive Council has taken a resolution, they should be regularized. Matter was sent for finance approval sometime in the year 2017 or 19.
Yes, Lord.
They were approached in 2023. Allegation is you are not working on it. Unless they get the approval from you, nothing
Yes,
happens.
When I did Lordship, I do not have the details.
WP, it was for the BTC and the same regulation, same 7066.
Yes, Lordship, I'm not.
It would help this code if you can find out.
Yes, Lordship.
Huh? Without your affidavit, things will not work. These are matters which can go either ways.
Lordship.
Let us send it somewhere. Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. Chaliha learned counsel appearing for the finance department, who has prayed for an accommodation for 2 weeks to file the affidavit in opposition and also to inform this court as to whether any other matters on the same subject are either decided or pending adjudication in this court. Full stop. The matter relates to the prayer for regularization of 7066 of the petitioners who claim to be a part of the 7066 OBB teachers appointed in the year 2001. Full stop. List this matter again on. Please give us a date, Mr. Chaliha.
Uh,
23rd of February 2026. Full stop. Mr. Chaliha has assured that the affidavit shall be filed by the next date fixed,
Or the appropriate instruction.
or with instructions he will not be able to answer anything.
I'll file.
You can't, again we'll fix the date.
No,
for
Lordship, I'll file it.
Affidavit will be, you file an affidavit saying these are the instructions.
Lordship.
Even that will do.
Lordship.
Full stop. The learned counsel appearing for the BTC authorities have submitted that they have been newly appointed and have requested the learned counsel for the petitioner to supply them a copy of the writ petition, as well as the other respondents. Who is respondent number 10? 10 has filed an affidavit.
Lordship.
Who is 10? Full stop. The
Director of Education, BTC.
Director of Education BTC has filed an affidavit. That will be for you to collect. The records contain an affidavit filed by the Director of Education, BTC. And also the Secretary Education, BTC. That is the respondent number 5. The counsels appearing for the BTC authorities would be prepared, are expected to be prepared with the pleadings on the next date.
Obliged.
No, the inquiry report has been handed over.
The inquiry report has not been supplied to him. That
Just
is
now
delaying the
we-
matter. Supplied.
Need some time to go through it.
The learned counsel for the petitioner has submitted that he has received a copy of the inquiry report, which was referred to in the last order, full stop. He has requested for also for an accommodation to be allowed to go through the same, full stop. Just a minute. Oh, September, we'll have to release it. Allowing such time to the petitioner, list the matter again on, when do you want it?
2 weeks later, madam.
2 weeks later.
2
No,
weeks.
you give us a date, 2 weeks, sufficient, 3 weeks, 4 weeks. 18th of February 2025, the matter will not be treated as part or any further.
Obliged.
May I please, your lordship? My lord, the elementary education department has been directed to file their affidavit, my lord. Affidavit has not been filed. My lord, matter pertains to.
In fact, this is the second round of litigation. Earlier, the petitioner was the professional and the petitioner preferred nothing. The opportunity was rejected. And the different order goes to process and he was not. The services of the petitioner was not allowed to the district level to come. Rather than it to the professional. So, we filed our affidavit for.
Why the affidavit if he was not, what have you challenged?
My lord, the petitioner and the private respondent both are language teacher, my lord. Petitioner is, my lord, Assamese, and the private respondent is English, my lord. My lord will file the details, the proforma on page 27, my lord. Page 27, my lord. Also, that is the proforma, my lord, prepared by the headmaster himself. That has been sent for provincialization.
Page number 27.
27, my lord.
Have you received the instruction, Mr. Sharma? No. From 2023, no
My lord, just
instruction.
for a moment, my lord. On the page, let me just.
Who has signed it?
My lord, that is headmaster, my lord.
Sujabha Thakur, who has been?
My lord.
Who is your respondent here?
Yes, my lord.
He is the respondent here.
He is
He
the
has signed it?
My lord, his name appears on serial number 1, my lord. He's English on the right side, my lord. And his date of appointment is 6/5/2002, my lord. Thereafter, my lord, Populla Kolita, the petitioner here in my lord. His date of appointment is 1/1/95. And on the, my lord, right column, he's Assamese teacher, my lord.
Mr. Sharma.
And after my.
Mr. Sharma, this the appointee,
My lord,
the
is that-
respondent has been provincialized as a tutor. As a tutor. Where is the language part? Very well.
One language, one time.
So now one language teacher. Now, if he has not been considered as the headmaster, he has to be considered as a language teacher. Who joined services earlier? Who joined the services earlier? So is that the affidavit that you will file that we have made a mistake? It should be the petitioner. No. How would you oppose it? Tell us.
Order into.
Where is it? Page?
Page number 40. Because there is a process, but district scrutiny committee has to recommend the name of those teachers who are to be provincialized. According to the state level.
So a state level scrutiny committee will be a post office. They will see whether it is properly stamped or not. They will see whether the requisite number of postage stamp has been given or not. And then they will say, okay, job done. That is how. Then we set it aside.
And apparently.
Is the proposal? What has it said?
It says
Your name is? Petitioner's name is what?
Surya Borthakur, my lord. Private
No.
respondent Surya Bosu, he is English.
You are Profullo Kolita.
Profullo Kolita, my lord.
Then what is this page 42?
Page 42 is the, my lord, order passed in the appeal by the, my lord, Secretary School Education. My lord, this is, my lord, this, the date of, my lord, joining is not mentioned herein, but otherwise it is resembles the performer, my lord. In the performer, Surya Borthakur is English, my lord. And, my lord, list of recommended teachers, and second, my lord, maths and science, and one Jibon Jyoti Kakoti, Hindi. Jibon Jyoti Kakoti's service has not been provincialized.
When can your DO Jorhat come with the records? When can the DO Jorhat come here with the records? You were heard in person
My lord,
by the,
my lord.
and the only reason given is that the DSC Jorhat did not recommend the name.
My lord, that is the sole reason.
Whether the recommendation was correct or not,
Yes, my lord, no
that was
objection.
required to be taken into account. They had to do what? For what?
Put the record.
Huh?
Put the record on what basis the private respondent was, otherwise data point.
You had your opportunity. The department had their opportunity.
My lord, so far as this, my lord, that, my lord, in the bottom, the mention in this, my lord, impugn order.
When were you appointed?
My lord, I have been appointed on 1195, my lord.
That has not been denied anywhere.
My lord, yes, yes.
Has that been contested anywhere?
No, no, my lord. Nowhere it has been contested. So far as the date of joining is concerned of petitioner, private respondent, my lord, they
Who
have not
appears for the
rejected.
private respondent?
Private respondent, some advocate was appealing today, he is not appearing, he is on the. On the,
Yes, item 1617 at a scroll deduction. Item 1617 not private respondent. We'll have it at 2. We'll have it at 2. Have you, if you want to have any instructions, have it on your PDF whatsoever you give it to us. Why the DSC rejected it? Otherwise, we are setting aside that provincialization. We are directing him to be provincialized. Salaries from the day he joins services. And the services paid to the wrong person to be recovered from the district level to the director's level. Not the director's level, everybody who was involved in the provincialization process. No post office businesses, please. At 2, kindly have your, if they have any instructions on it, have it from the Jorhat. The DO Jorhat can send you the DSC report. Why his name was not there?
27.
Mm.
Data point is senior to the
Therefore,
respondent.
they have to give a reason why his name was not considered.
That report was prepared by the respondent himself. In the master.
So at 2, kindly have your instructions from the DEO, Jorhat. The concerned person who was the DEO at that point of time, the salary recovery starts from him. And it will go to the government coffers. At 2. At 2. These are small matters. We just have to instill that thought in the mind of the persons involved in provincialization that there may be mistakes, but there cannot be. Yes. Next. Obliged. But he's not here. So none represents. At Hegel. Huh? At 2 p.m. Yes.
Supplementary item 55.
Yes.
Secondary education is there, my lord.
Yes.
My lord, the matter has already been heard by the, my lord, ADC Borpeta, my lord. But as
By the ADC Borpeta.
Borpeta.
Then it is the ADC Borpeta who has to tell us why he's
Well,
not passing an order.
As yet, the final order has
Uh-uh.
not been. Otherwise, your lordship also dispose of the same by directing him to pass.
Yes, who appears for the ADC? For the DC Borpeta? You appear. Why was the hearing taken by him?
My lord, application representation was also filed before Director of Secondary Education.
Huh.
A copy of the same was also given to the DC, my lord, being the chairman of the, my lord, scrutiny committee regarding selection and appointment of the, my lord, private respondents. The matter has already been heard, my lord, but
Yes,
my lord,
madam, kindly have your instructions. You can go through the records, will permit you. This flagged thing marked as X. The ADC Borpeta had taken, the DC Borpeta had taken a hearing on 3/1/2025
Yes, yes. I'll bring instruction.
so
at 2.
Okay.
At 2. At 2 or he will come with the instructions.
at two.
They are busy people, have it from anybody. There's a file number. There's a file number on the letterhead. Anybody can give you that information why the decision is not being taken. We'll at least have the right person to give a direction. We are not calling him today, but he will have. Yes.
Too many.
Here, item 70, the other time to file the affidavit. If you the case, my lord, the petitioner has died in 2011. And in 2024, they have filed this petition, which is regularization. You know,
Of that period. Who has filed? The family?
family.
It is not regulation, a family pension.
Family
What if-
matter for after regularization. Work charge employee matter. Work charge employee matter. So if we go by the prayer, first regularization, then only my lord. Pension doesn't fall my lord without regularization. So there are the aspects, my lord, that I have to click on record management. Page number 24, the prayer part, my lord, the survey of the house, the applicant shall not be regularized before it there. So now they have.
Though the husband of the petitioner had completed more than 36 years of continuous service, including 16 years of work service against the sanctioned vacant post, page 10. Page 10 of the petition, sir. Then page 11. We'll give you the time. The affidavit does not come, perhaps you can be prepared with the law. Matter of pension.
I am,
It is a yes or a no.
but this was sent for.
Mediation, yes.
That is the-
Mediation has failed, we will record that.
For the topic.
The matter was sent for. No,
Copy লাগিছিল extra project.
by, take it down like this.
পিছত দে না extra copy
Heard the learned counsel appealing for the parties
extra copy দিব লাগিছিল petitioner book.
by the order dated 18/12/2025.
So they didn't.
The respondents were required to file their counter affidavit, failing which consequential order would be issued by the court. Full stop. Mr. Ardhar, learned counsel, appearing for the respondent, PWD has submitted that the counter affidavit is under preparation and will be filed shortly, accommodating the respondents for 2 weeks. They are allowed to file their affidavit in opposition on or before 12th of February 2026. Full stop. List this matter again on the 18th of February 2026. This opportunity shall be treated as the last opportunity being granted to the respondents to file their affidavit.
Item 18 to 20.
Yes, sir.
My lord, in these 3 items, my lord, the petitioners are the subject teachers in the vocational stream in the secondary schools, my lord. And in my writ petition, my lord, I prayed for the similar pay band that have been paid to the similarly placed teachers whose services were regularized in the year 2000. And our service was regularized in the year 2012, my lord.
Hmm.
We have discharging, my lord, the same amount of service. But my lord, we have been paid payment 2, whereas the similarly placed teachers have been paid payment 4.
Hmm.
And my lord, there is a recommendation by the pay committee for 3 increments. But my lord, our prayer is to my lord to get us the benefit of payment 4, my lord. And to that effect, my lord, no affidavit or instruction has been placed by
Who is required to
my lord, in this respect, my lord, no
Can't you repeat?
affidavit and instruction has been placed, my lord.
affidavit? No affidavit has been filed. What do you say?
There is some instruction, my lord, as to the extent that the pay commission had recommended that in between grade pay of 3,300 is to be introduced in their favor. So in that respect, some recommendation and the financial implications are being discussed, my lord, among the respondents. But then where?
Through my affidavit.
Huh.
Page 115, Lordship. Filed by the Finance Department.
Calculation.
2890.
Page 115, 2, 4 and 5. Yes.
Lordship, here, Lordship will see, that's the 7th NPPC examine the memorandum submitted by the All Assam Vocational Teachers Association, White, so and so, of its report recommended the following. The commission has examined the demands of the part-time vocational teachers in detail. It is observed that 158 part-time vocational teachers are demanding pay scales as have been given to 274 vocational teachers who were appointed earlier on regular posts by the department. The commission observes that the two cases stand on 2 different footings altogether. The commission has also observed that these 158 part-time vocational teachers were regularized as an equivalent number of vacant posts of assistant teachers which were allowed to be converted to the post of vocational teachers with grade pay of 2,400. In view of this position, the commission recommends the teachers who have basic qualification equivalent to HSLC shall be given grade pay of 2,400. The teachers who have basic qualification equivalent to graduation should be given a grade pay of 3,300. Teachers who have basic qualification equivalent to post of graduation shall be given the grade pay of 3,300 and 3 additional increments. The above recommendation will be valid for each group of teachers irrespective of the trade which they are teaching. Now, Lordship, here, the next paragraph, Lordship. A nominee committee was constituted by so and so to examine the recommendations of the separate. The All Assam Vocational Teachers submitted a representation to the effect that the recommendation of the 7 had deprived 19 numbers of vocational teachers from getting payback 4 with grade pay of so and so. 16 vocational teachers deprived from getting grade pay with PB2 with grade pay of 5,100 and 51 vocational teachers.
You want 3,300 and you are getting 2,400. No.
Yes, ma'am. We want 5,400.
5,400
Because that
and
is what the others who were, my lord, earlier regularized in 2000 are getting, discharging the same job, my lord, having
no.
the same qualification.
Earlier 274 according to this affidavit
Yes.
were appointed on regular post, whereas you were regularized against sanction posts.
My lord.
The regularization order had converted posts available in the grade pay of 2,400
Yes.
to accommodate you. So therefore now you are drawing 2,400.
Yes.
5,400 would come in for those who were appointed on the post of 5,400. Your fight is that since we give the same job in the same kind of school,
Yes.
there is no difference of anything, so the pay scale should be same.
Right.
This anomaly committee 3,300 we don't understand. Why 3,300 we don't understand.
If there is a revision at all, it has to be, my lord, in the
Equal pay for equal work will not act everywhere.
Yes.
Within the same department, same schools, same post, same work done, same educational qualification. Those 158 who were appointed on regular post,
Yes.
they would also have a difference of, they could possibly have a difference of their basic educational qualification.
Yes.
For them, you are giving 5,400 to all. Why for them this differentiation, sir?
Look, yes, Lordship, here, if page 117, Lordship. The matter was examined in finance PRE department and it was observed that the proposal of education department lacked certain important information like financial implications, budget.
Oh, this is only if you want to give 3,300 and 2,400.
Yes.
The main issue is why not 5,400? How can you deny them 5,400 is the issue if I'm understanding it correctly, I don't know.
Now, for that also to be considered, Lordship, now the eighth pay commission will be there, Lordship. So
Whosoever is there, can equally placed public servants draw different pay scales?
it's on their qualification, Lordship.
Exactly, for 154, the qualification is not a factor, everybody gets 5,400.
Yes.
The second batch comes in, you say within you, 274, we will have it based on the qualification. Then why not for the 154?
154 are the new ones.
Are the old ones? Oh, no, sorry, 158.
158 is a new.
274 are getting it without any difference, whatever their basic qualifications are. Everybody is getting 5,400. Now you decide to regularize 158 persons.
Yes.
You regularize them. For them, you will fix the pay according to their educational qualification.
Right.
How are they different from the 274 persons is what we are asking you, sir. You are the finance.
Yes. How that
They will give all the justification.
Yes.
You will reject it. On what ground? That is what we want to know today so that we can decide and leave it on your table.
why the disparity?
Yes. Why do you propose different pay scales for same nature of work executed by both the groups of vocational teacher? You could have done it on the basis of the education, minimum education that they have acquired, provided others in the same class had been subjected to that sort of a treatment. You don't do that treatment for those 274, meaning you are not taking their basic qualification as a ground for classification, reasonable classification. Can you do it for another set of teachers? Can you bring in that classification is what we want to know. If you cannot, matter ends if you can, because now they are paying for 5,400.
Yes.
We have been asking for reports 3,300, financial implication 3,300. End of the day, they will come back with the case saying that it is 5,400, 3,300 gone. Doesn't work. Then what happens? Then why the work? Why all the pain? Just because an anomaly committee says something. We are trying to understand, sir. We are not against you for them, for you against them, nothing of this sort. We want to understand what relief can be granted, if not why. Mr. Khatonier, your department has to propose. Proposal submitted at what? 5,200? Huh? I was given 2 pieces of paper by someone. Huh? There are 2 batches of people. One, 274 numbers who were directly appointed to certain posts. They were regularized. Posts were converted. Those posts at that point of time were 2,400. Now, their affidavit says we can give them 3,300. You are giving a calculation of 5,400. They will give it back to you saying that the anomaly committee this and anomaly committee that. And you are anomalous and when?
On 9/12,
Huh?
the exact number of department leaders.
On 9/12. On 9/12, it is to you. That letter is to you. Who appears for the Director of Secondary Education? Who appears for the Director of Secondary Education? They have a different set of counsels. Okay. So what does the director say?
Is it in respect of 5,400 or?
We have this. Good idea. এখন ঘুরাই দিও। What does the director say?
That involves 3 items. Whether it is 400 or 300, my lord. That is also not reflected in the,
Hmm?
whether it is in respect of 5400 or 300, that is also not reflected in the.
That we can show you is reflected in the writ petition itself. We saw it. Where? There is something in the writ petition where the process was started. Ah. When will you have your instructions? We want to do the matters. No help is coming.
But after 10 days, my lord.
Hmm?
After 10 days, my lord.
Tell us how it can be something else. Why 3300?
Regarding that, I'll.
Your affidavit only says that the anomaly committee says it should be 3300. Did the anomaly committee take into account the other persons who are drawing 5400? Anything to do with that 5400? Anybody have stated that they are not entitled to 5400? This writ petition has now become a tool for them to get anything beyond 2400. Cannot be that. It has to be correct at the first instance. Whose affidavit replies this?
This is filed by us.
You are respondent number 2. Yes, School Education Department, page 101. Do you have the reply filed by the petitioners? The reply affidavit filed by the petitioners? No. This has been filed by you, Mr.
Yes.
Deka. You did not give a copy to the standing council?
Yes, my lord.
No? Ah, yes. CP Haloi.
Yes, my lord. Page 101.
You have 101.
Yes, my lord.
Kindly see. In the humble submission of the petitioners, the finance PRE is willing to grant equal pay to the petitioners. However, for reasons other than bona fide, the respondents in the school education department is sitting over the matter. And then letters are being written on a day or two prior to the listing of the case. Is it? See, on 9th of December, praised for and granted further 3 weeks time to obtain instruction. This is 9th of December. Is it not? On the day the matter is listed. Then this the matter again on after 3 weeks. So 9th of December in 3 weeks. So therefore on 16th of January this comes up. We have some tendency to believe the assertion. Now this instruction that you have given us, total exact number of vocational part-time teachers required for equalization of pay. Shall we record in the order? It is 158. It was your document.
Yes, ma'am.
That there are 158 number of persons. Then some may have retired and some may have not.
Not everybody.
That cannot be a ground. Total financial implication involved. Budgetary provision provided for in the financial year. We'll never have it. Because now we'll be in March, so it will be 26, 27. Heard Mr. R.M. Dekar, Learned Counsel for the petitioner, also heard Mr. B. Pathak, Learned Counsel for the petitioner, and Mr. M. Hussain, Learned Counsel for the petitioners, appearing in their respective writ petition. Full stop. This court observes that when the matter was listed on 9/12/2025, an instruction was issued to the standing council on the same date, stating that the department has resubmitted the proposal on the additional financial implication in respect of upgradation of the grade pay of vocational teachers per so and so for their views and comments as sought for. Full stop. Today, another instruction dated 16/1/2026 has been placed before this court, whereby the Secretary of the Government of Assam, Department of School Education, has requested the director to furnish the department the details regarding the demand of vocational part-time teachers pay parity with vocational full-time teachers in respect of WPC 3521 of 2024 for onward submission to the Finance PRU department. The information sought for are the total exact number of vocational part-time teachers required for equalization of pay, total financial implication involved, and the budgetary provision provided for in the financial year 2025-2026. Full stop. This court observes that by the order dated 25/11/2025, this court had recorded that the Department of School Education had been requested by the Finance Department to resubmit the proposal on the additional financial implications in the event of upgradation of grade pay of vocational teachers as per the 7th Assam Pay and Productivity Pay Commission. Full stop. It appears that the instructions being provided are of a similar nature, being done only as and when the cases are slated to be listed. Full stop. The affidavit in opposition filed by the Finance Department refers to the advice given to the Education Secondary Department to examine the matter in detail again by endorsement dated 27/1/2025. List this matter again on, when can we have it? After 10 days. Immediately. After 10 days. On so and so date. On which date the respondent authorities, don't write it. Should we say requested, or should we say ordered, or should we say implored? What should we say? When would they react? At what stage would the department react?
It is very difficult to say on my part.
I know. Ordered. It is directed that the respondent authorities would be in a position to resubmit the proposals to the Finance Department. The Director of Secondary Education and the Secretary to the Government of Assam Department of School Education shall furnish appropriate instructions to the Standing Council as to the status of the preparation of the proposal and or reconsideration and or the stage of submission at their own office levels. Full stop. It is noticed that today no instructions have been produced from the office of the Director of Secondary Education in the matter. List again on KTL. Yes.
They will also take instruction as to why 5400 is not given to us, my lord. Because all the instruction related to 3300, my lord.
Let them put up a proposal
Proposal, my lord,
either on 3300 or on 5400.
can be reflected in the order, my 5400, my lord.
That is what they are saying.
My lord, 3300 proposal is already there.
Already there, my lord. 5400 is not there.
The
They
16 one has some
have
answers
said
actually, which has
they have
only
said it
been
is
produced.
3300 in their affidavit.
Yes, ma'am.
Education department is saying nothing.
Whether it's 33 or 5400.
They are saying that it should be considered like this. There's no writing down. So once the education department says it is 3300 or 5400, finance is only the office which will grant it or reject it by giving a reason. Something has to go from here. Then if they take it up to be 3300, then you have to challenge the 3300 part by filing something in this court.
The 3300 part is also.
Our observations which we are making here by going to the file is not going to help your case.
Right.
So that 5400, whether they're proposing of 3300 or 5400, the department.
Well,
Therefore, give him a copy of the affidavit in reply if he does not have one.
well, I'll serve.
It will help him.
Definitely, madam.
Yes, next.
Reply.
22.
Yes, Mr. Lashkar. Tell us.
Lordship, madam, will be taken on next week, my lord.
Why?
The engaged counsel, Mr. B. Losky is out of station.
Yes, sir. From where have you verified that it is 24 or 28? Any affidavit filed?
Earlier one evidence was filed also,
Hmm.
whereby notice is filed at page number 42, paragraph number 7. The reason for not installation was stated.
Where?
Page number 42 lawsuit.
Huh?
Affidavit filed by the director. Education Department.
Hmm.
It showed that
Hmm. This number of student has to be on which day?
Number 40. Number 39. So the relevant
You say that they do not have 30 students.
enrollment position.
Huh. Now, what is this page 36 then?
Lordship. This page 36 apparently issued by the district elementary education.
Huh?
30
Not apparently.
Lordship.
It is issued by?
District elementary.
It is issued by? From district elementary. It is issued by district elementary, yes. And he says it is 31, 37, 41.
Lordship. 17 it says 31.
Huh?
2018 it says 37.
Huh?
19 it says 41.
Huh? So from where do you make a statement that it was 30 students? Is it based on records? It is based on records. That particular, that statement in the affidavit, is it based on records, sir? Oh, yes, it is part. So can we have the record? Show us. It is not annexed.
Otherwise,
From which record did you find that it is below? Hmm? You don't have the file.
Lord. Actually, due to some family problem, he has gone to his native place. Due to family problem, he has gone to his native place.
Page number 28. Page number 28, para number 3.
not actually.
So at some point of time, you say district scrutiny committee has not considered, therefore we will not give it to him. In this case, the district scrutiny committee says considered. But you say that district scrutiny committee is wrong.
Otherwise,
When will he be here? What day?
On next week, or not any date.
Next week, any date. On a prayer made by the Learned Council for the petition, please be prepared on that aspect. On what you have said, it is on a basis of records. He has produced the records, you have not. He has given the record that he has got 40 students, 37 students, whatever students, signed by the district elementary education officer. And in your affidavit, you have said matter of records, here he does not have 30. Record is not given to us. If on the next day the record is not here, then any statement made in an affidavit on the basis of records not being produced, statement is rejected. 6th of February, 2026.
Hours.
For further hearing, yes. Huh? Yes.
Lordship, they have taken time earlier also since last year and they have not filed in their affidavit.
Which provision of law entitles you to the family pension?
Rule 54, subsection 6, subsection 3 of the Central Services Pension Rules 1970.
Have you given an extract in the petition?
Petition, yes, Lordship, page number 8, point number 8.
Page number 8.
Point number 8.
No, have you given an extract?
Oh, no, Lordship, that part we have not annexed.
To an unmarried daughter up to what age?
Unmarried daughter, it's written, Lordship. It's the age is not mentioned, plus the petitioner here is suffering from multiple disabilities.
Also
He
with
is deaf and
disabilities?
dumb.
No, the issue was simple that we understood. Her mother's name did not match.
Yes, Lordship.
You made an enquiry through the police. Mother's name matches. Matter filed
So last year, 2025.
in 2025, early part of 2025. Is it not? And all that you are required to do is tell us how can she change her mother's name? Why was the name not matching, madam?
Lordship,
Why
actually,
did it
her
not
moth-
match?
Two different names were recorded. Two different names of her mother was recorded. Her nickname was recorded in the service book, and in other official documents, her official name was recorded. Sucharita is recorded in her service book, Lordship.
In the service book of the
Petitioner's father, Lordship.
petitioner's father.
Yes, Lordship.
And thereafter, but in all the other documents,
Malti De, Malti Das is recorded.
so what is she now required to do? A dead man's all documents or dead lady's documents, she has to go and get the name changed everywhere. She has to make a request to each of the departments who had issued those official documents that my mother is gone and I am required to change the name of my mother now. Can she do it? Can anybody change their mother's or father's name? Why are you doing this? Next week? Next week for disposal. That is your only ground that the name does not match? Any other ground given to you in your instructions? Do you have the instructions? Huh? Which is the authority, madam? Heard Miss So-and-so learned counsel appearing for the petitioner. Also heard the learned counsel appearing for the respondent. Full stop. This is a petition where a disabled daughter is praying for grant of family pension in accordance with the rules. And the only reason which is where do they say why they have rejected you? Any rejection order is there? Which is available in the order dated 26/2/2024. Is that the name of the petitioner was not found in the service records of Neil Ratan ex Havaldar within bracket late Neil Ratan Das. The petitioner was therefore requested to give all the documents for a verification through the district Sainik Welfare Office. By a communication dated 4th of November 2024, the SRO, all in capital, for OIC records has advised the petitioner to change the name of her mother in all service documents as per name of wife mentioned in the ESM service record. Full stop. There is already a report dated 18/6/2024 dated 26/2024, issued by the Office of the Superintendent of Police, Kachar, Silchar, Assam, addressed to the Zilla Sainik Welfare Officer, Kachar, that late Maloti Das, who was the mother of the petitioner herein, was also called by her nickname Sucharita in the locality. Full stop. The Learned Counsel, appearing for the respondent, has prayed for some time to file their affidavit in opposition and has requested that the matter may be taken up next week. Full stop. It is noticed that the petitioner is a 54-year-old disabled lady. Full stop. On the next date fixed, the respondents shall furnish appropriate instructions to the council to apprise this court as to whether the petitioner would be required to change the name of her mother in all her civil documents as per the name of the wife of the deceased employee. At a time when the mother of the petitioner is no longer alive. Full stop. The respondents shall also furnish appropriate instructions before this to their counsel to apprise this court as to the requirement of such a change being incorporated when the Zilla Sainik Welfare Officer had conducted an inquiry, had got an inquiry conducted through the Superintendent of Police, Kachar, Silchar, which has reported that the mother of the petitioner was known by two names. Full stop. It is made clear that in the absence of instructions, which may also be placed before this court in the form of an affidavit, this court will proceed to decide the matter on the basis of records available before it. Full stop. Place this matter again on. Please choose a date. Have we given a date? No. Please choose a date.
Okay.
16th of February. List again on 16th of February at the request of the Learned Counsel for the respondents. At the request, no, as requested, Koriba, huh? Yes, sir.
And there was the order dated 24/11, madam. But till that, no affidavit has been filed. Matter pertains
What
to-
was this issue regarding death in service not attributable to government duty?
But the petitioner.
Where is that scheme? Have you given the scheme in the paper? And
But after NPS, my lord, the husband of the petitioner, my lord, fall under the NPS, new pension scheme. In pursuance of the government notification, kindly see my lord page 30.
30.
14 June 2016.
30.
30.
Ah.
Issued by the Pension and Public Grievance Department, whereby decided to pay the provisional basis pension. Kindly see paragraph 4.
Whereas a high-level task force constituted by the government of India has recommended for extending certain additional benefit on death or discharge.
How did
And
how did the husband expire?
expired on Malat 12/2/2015.
Where do you find that? Do you have any certificate on it?
Malat
60.
service book,
Death certificate.
death certificate. Malat.
Ah. Yes, how did he expire? Have you given any statement? He was not keeping well or he was not.
Malat, during the course of service, Malat, he died.
That is the first question this court had recorded.
Malat.
That it should not be attributable to government duty. What was he serving as?
Malat, he is serving as Malat assistant teacher, my lord.
Mr. Attorney,
Yes.
if the death is attributable to
Government.
or not attributable to, then he will get a family pension computed in terms of Rule 140 and DCRG. Let us assume it the other way around. He dies in duty attributable to government service. He will get something more. He cannot get less. He has to get something more if he dies during the course of duty. That is provided for in the next page at page 32.
Yes.
He will get extraordinary family pension. He will get special family pension. He will also get the DCRG. So once he dies in service, whether attributable to government servant or not, government service or not, he has to be given the DCRG. Has he been given? Has he been given? That is okay. And from 2015, you wake up in 2025 that you get money.
Malat, I have submitted representation, my lord.
Where is it?
Malat, kindly see Malat
Page 48.
48.
Page 48. Where is the receipt?
On Malat.
Where is the receipt?
But subsequently it was forwarded, Malat, page 49.
24.
Malat,
In 2024,
Malat, 24.
DCRG in either case, she will get.
Yes.
Whether it is family pension or EOP. That is the only issue. But can she sit home without getting anything?
On this,
This writ petition had been, a notice in this writ petition had been issued on 14/5/2025, full stop. The claim of the petitioner is that as per the, what is that office memorandum? As per the office memorandum dated 14 June 2016, she is entitled to be paid a provision, family pension
on provisional basis.
computed in terms of Rule 140 and Rule 143 of the Assam Services within bracket Pension Rules 1969 and the DCRG computed in terms of Rule 135 within bracket 2 of the Assam Services Pension Rules 1969.
On this regard, subsequent office memorandum is also page 44, my lord.
The learned counsel for the petitioner has submitted that by a subsequent notification dated 1st of February 2021, the employees who were covered by the National Pension System would be covered by, would be eligible for the benefit of retirement gratuity and death gratuity on the same terms and conditions as are applicable to employees covered by the Assam Services Pension Rule 1969, full stop. The husband of the petitioner expired on
12/2/2015.
full stop. On the next date fixed the Learned Standing Council for the Secondary Education Department shall apprise this court as to whether the DCRG benefits have been released to the petitioner and whether any proposal for granting family pension or extraordinary pension has been processed. Full stop. Since the matter relates to a prayer for grant of family pension, it is expected that the respondent authorities would act with urgency, at least to supply appropriate instructions to the Standing Council. Yes.
List again on my.
The list on? When can you have it?
Week 1, 2 weeks.
17.
Oblige.
25.
Yes.
But before I start, my lord, your lordship was the standing counsel for the higher education department.
Ah,
While in the
good.
earlier round of litigation during suspension period, this petitioner filed.
Sorry.
This petitioner filed
Mm.
writ petition for regarding suspension.
Ah,
And at that point of time, your lordship was the highest standing counsel of the higher education department.
ah.
So if your lordship takes up, I have no objection.
No, did we deal with this file?
This not particular this matter, but his case. He was the
No, it is up to, I do not know. Once you point it out, it is an indication that we should not take it up.
it is not
Huh? What is the prayer here?
There is nothing but gratuity, my lord. It is not paid and GIS. He has retired all this. All
Why has it not been given to you because of the suspension?
No, not suspension. They have issued non-liability certificate, my lord.
Mm.
And even after that, they are not giving, my lord.
No, first let us come to a conclusion. Should we take it up or should we not take it up?
Your lordship may take up, but I have no objection. I have nothing.
My lord, in fact, what happened now, my lord, the matter, I think the of the government would be required. Because we have sent the matter to the government for taking a decision in respect of the leave salary. If the government.
My lord, the affidavit the college has filed, my lord. It admits that I have utilized the fund. And they are trying to impose, my lord, liability upon the petitioner. It is not established through their affidavit, my lord.
It is not established through their?
For their affidavit.
Where
They
is
have
their
filed-
affidavit?
They
You
have
have filed
filed
the
two
affidavit.
affidavits. No, the government, the college has filed two affidavits in this petition.
We have filed, there was a inquiry committee. And committee found serious irregularities while he was the principal in charge. Therefore, the group insurance is proposal has been sent. So for as leave salary, no liabilities have been.
Leave salary is, what is to be recovered from the leave salary? What can be recovered from leave salary?
It is
Why no liability certificate is given? That if something is recoverable from him, the same can be recovered from the
Yes, sir. From pay-
21B.
The FR
Pension
also-
rules conjunction. We are going into this matter so that on the next date, if it is before us, you would be aware
Yes, sir. If the
about
government takes it.
Assam pension rules.
If the government decides to make payment, there is no problem for us.
21B niki? Rule 21, 22, what was it? That liability part?
Financial rule, my lord.
No, some pension. When can it be withheld? Ah. Even if you start a departmental proceeding, then gratuity or debt cum retirement gratuity can be withheld. Can the other part be withheld at any point of time?
That is paid already.
DCRG is paid,
Yes,
GIS is paid,
GIS awaited.
leave salary, handled by the appointment. List this matter again after 2 weeks. List this
At a
matter
date,
again
my
of
lord.
what? Give a date. Allowing the
A date, my lord.
uh,
No.
this is matter again on 20th of February, allowing the higher education to file their affidavit in the
To
matter.
clarify their stand, my lord. That's-
Huh?
To clarify their stand.
May it please your lordship.
Yes.
Lordship, here we are praying for compassionate family pension. A petitioner's son who was working as an assistant teacher, lordship, in Newtown MA School in Hailakandi. He has died and harness on 6/6/2017. Lordship, on 14/9/17, OM was issued introducing the scheme for compassionate family pension in lieu of compassionate appointment, lordship, for those who died in harness. Again, lordship, on 18/6/18, another OM was issued with regard to submission of claims on additional relief from debt, lordship, of any government servant, which is covered by the NPS, that provides opportunity to take informed decision as to whether the claimant seeks to opt for an monthly annuity or additional benefits like family pension. So lordship, petitioner was paid the whole NPS amount on 29/11/2017 without giving her the opportunity to opt for any compassionate family pension. And later on,
She was paid the entire amount even before the 2018 clarification came.
clarification came, yes. So lordship, on June 24, she has learned that she could have been given this opportunity, so.
But
she
in that
is
case,
not-
you have to refund the entire amount.
They did refund that amount, lordship.
Who's appearing in this? Yes, madam.
They were supposed to file an affidavit, lordship.
Let us find out. Yes. Huh? What does it say? This also we will do now. We will also go through parawise comments to find out a case. What is this 27/9/2024? What does it say? No. Here in your affidavit in opposition, in your this thing, you have referred to a government notification dated 27/9/2024. What is it? PPG. You are PPG? Pension and Public Grievances.
Sure.
We'll have it at 2. Kindly find out what is this instruction.
Lordship,
It's.
Anything there?
Yes. The department is responsible.
The department is? Who is the department? PPG. Huh? Acha, tell us, sir.
lordship, yesterday. Yesterday, in Honorable Court 18, similar matter was there on item number, Case number 5627/2025, Ram Singha versus State of Assam. So, কি নাম আছিলে? P. Nayak was asked to take instruction and the matter is fixed on 6th of February. So let
Okay, you
this
should.
matter.
The counsel for the petitioner submits that a similar issue has been agitated in WPC number
5627/2025.
of 2025, full stop.
Next item also same. Not
List this matter along with the said writ petition, which is slated to be listed on the 6th of February 2026. Both the matters, huh? Duta matters. Kun duta?
27. Lordship, next item also same.
Same days.
Yes.
একেলগে দি দিম।
Oblige.
May present. That by order dated 15/12, they were
Ah,
supposed to.
is the road leading to Rome? Or is it leading somewhere else? It should lead somewhere else.
No, my lord, another thing I want to point out, lordship, may come to page 33. The lordship was appearing for the petitioner in a batch of petition.
In that batch of writ petition. Yes. Then?
Well, I am just pointing out, my lord.
So once we touch a subject matter, we are not supposed to take it up as a it will be dangerous. No,
That
here
I
you
need
see,
to-
here you see,
Lordship.
this was a writ petition against the order of the cat. This is a writ petition against
No,
the order
subject
passed by
matter-
the CAT.
Subject matter is different. Only your lordship was appearing in this second writ petition, he was one of the petitioner, the present writ petition.
Which one?
Your lordship may come to page 33.
33.
Yes, madam.
Huh.
Serial number 2, WPC 2228, 2016. This present petitioner was departed.
List the matter
Yes, madam.
without me.
Just I came.
Thank you.
Always.
Otherwise, question of proper forum will be raised by,
No, it was raised, my lord, lordship, on.
it was not
15/12
overcome. That is what we have seen.
15/12, they were directed to file the affidavit. The
To do
point
what?
will- Yes, my lord.
To do what? Are you not prolonging the agony by keeping it hanging in the High Court when the matter is supposed to be in the cat? Is it not prolonging the agony of the petitioners? They have a relief.
My lord,
They have a good hope of relief.
my lord,
It is to be adjudicated
my lord.
in the wrong forum. You get a very favorable order here.
Yes.
It goes in SLP or in a writ appeal, wrong forum. Then it is taken up one step higher, wrong forum. The matter is never adjudicated upon. Can you imagine the agony of those persons?
Yes, ma'am. Yes, ma'am. That is right.
To entertain a argument, we are lenient. We let arguments happen. But if it is not on the merit of the case, does not everything suffer? Yes. Educate number 29.
My lord, just now I come to learn that the APDCL has filed the affidavit in the matter.
Yeah.
But my lord, the copy has not been served upon us, my lord. I'm
How could they file it?
My lord, in fact, the private
There
respondent.
is a judicial order
Private respondent have served the copy. I have checked the notice, my lord.
here.
Yes, my lord. In the
When-
affidavit
when-
filed
when
by
did
the
they file it?
APDCL. They filed it in November, 20th
November.
November, I think, my lord. They filed it.
You don't want to give copies APDCL. Who appears for the APDCL? Please ask him what enmity he has got with Mr. Deka not serving him copies before filing.
Let them file a survey copy, my lord.
Please serve a copy to him during the course of the day. Miss So-and-so appears for Mr. I. Thakur, Learned Standing Council, APDCL, Mr. R. Deka. RM Deka, Learned Council, appearing for the petitioner, has submitted that he is yet to be served a copy of the affidavit in opposition filed by the APDCL. Full stop. Ms. So-and-so undertakes to serve a copy upon Mr. RM Deka, a copy of the affidavit in opposition upon Mr. RM Deka during the course of the day. Ms. So-and-so appears for on 26 November. List this matter again on. Dear date ka dear. When would you want it? It is up to you.
At least my 2 weeks time may kindly be granted to file the reply, my lord.
It is
So,
your case. You take as long a date as you
first
want.
week of March.
First week of March, did you? Yeah. 6th, 5th.
Interim may kindly continue.
What is the interim?
My lord, I have been reverted back to the post of assistant headmaster, my lord. I am presently.
Oh, that case where you were promoted on the day of your appointment itself.
No, my lord. Pursuant to the meeting, I was promoted because I have the BA.
When did you join the service?
My lord, I joined the service, my lord.
Some file conference. Do you need the affidavit?
On 11/9.
1992. On?
1992, I was appointed as the assistant teacher, my lord.
Ah.
And 1995, I completed my BA degree.
2024.
And my lord, I was promoted to the post of headmaster of the school on 17/1/2024. I was being promoted to the post of headmaster by taking into consideration my BA degree, and the respondent number 4 has not possessed the BA degree, my lord.
Why have they cancelled it? Why have they cancelled it?
My lord, there is what was in order?
You don't have the affidavit. She is not prepared to argue.
Yes, ma'am.
Yes, list the matter again on the 1st of March. You are appearing for the private respondent. Huh? There is an IE. Have you filed any interim application for interlocutory application for vacation of stay? Eh? Third week of February, did you? No, third week of February.
27th January.
Huh?
27th of February.
27th of February.
Friday, ma'am.
27th of February. Interim order passed earlier. Shall continue.
Deeply obliged, Lord.
44-0. 30. Abdul Hussain SK. Yes, join services.
Sanction.
Huh?
As per our instruction, lordship, they are not written lordship. They are yet to get the sanction from the government lordship. And thereafter only these will be provided in the deputy.
Lordship will kindly pair with order dated 26/11, your lordship.
Huh?
It's 26/11/2025, your lordship.
Who appears for the Deputy Commissioner Dhubri? Who appears for the Deputy Commissioner Dhubri, ma'am? When can he come to the court, madam? If you, do you have the copy of the order of 26/11?
They are stating that they already have their budget, proposal has already been submitted before the government lordship.
Government means which department? To whom?
Revenue department.
Huh? Apparently, it was as duty duty for all purposes. So that is that. Deputy Commissioner has not given it. 19.
Submit the clarification report. But that was not submitted, no, that's why it was not, that's part of, that part of the system, but that's part of the financial, they have to clarify regarding the.
It is submitted on 29/10/2025 lordship, and this was.
Already proposal was submitted, that how much amount the application has to be paid, that amount has been submitted. And regarding the period, my lord.
Heard, Mr.
Suspension period, that was submitted, my lord, was not paid.
You are appearing for
Revenue.
Revenue Department. And you are appearing for the deputy commissioner. You are appearing for the deputy commissioner, madam. Heard Miss So-and-so learned counsel appearing for the petitioner, also heard Miss M. Bhattacharya, learned additional senior government advocate for the respondent number 4 and 5, and Mr. J. Hendig, learned standing counsel, revenue department, respondent number 1, 2, and 3. During the course of the hearing of this case, there appears to be some confusion as to a proper proposal for payment of the arrear subsistence allowance to the petitioner had been made by the respondent number 4 to the office of the respondent number 2. Full stop. List again on. Give us a date. 12th of February 2026, on which date the respondent number 2 and the respondent number 4 shall depute their representatives to attend the proceedings of this court along with all records necessary to apprise this court as to why the arrear subsistence allowance to which the petitioner is entitled to has not been processed till date. It is provided that in case a proper proposal is submitted and the same is processed in accordance with law, the attendance of the deputies of the respondent number 2 and 4 would not be required. However, if the process is not, it would not be required, full stop. List as fixed before. 12th. By 12th, just have the proper proposal sent, process it properly.
Lordship,
We are not bringing the deputy commissioner or the director on 12th. If we find the same thing happening, if the process is not done correctly, they would perhaps be required to come.
Lordship,
Good enough, they need not appear.
there is an instruction dated 31/10/25 by which if the proposal has already been submitted,
Let me explain. They have sent a proposal.
Lordship.
The period of service has to be regularized before the payment can be made.
Lordship.
How it has been regularized has not been sent from the deputy commissioner. That comment has not been sent. This is what we understood when we heard the arguments. And this is what you would have understood if you had paid attention to what was being said.
Lordship.
You have to pay attention that side also. Yes, sir.
Deeply obliged.
Earlier matter, my lord, item 29. The petitioners have submitted, my lord, that the affidavit filed by the APTCL was not being furnished upon them, my lord. However, that's not correct. There's a signature of their junior in the notice.
No, my lord.
Well, in any case, file of
Yes.
In any case, my lord, there's some urgency. We're enjoying a stay order, my lord. I'm on the verge of retirement, my lord. Can it be before 27th? That's the only prayer, my lord. There's some pressure from the client also. Next week, my lord, they have received the affidavit. My lord, kindly see.
No, my lord. No, your lord. In fact, we will not make that wrong submission before this honorable court.
I understand.
I don't think any trade you.
I understand.
Just for.
Actually, we fixed the wrong date, Mr. Dekar. You should have pointed out. She was praying for 3rd week of February. And you got it in the last day of February.
Yes, my lord.
Anna. We'll have it on the 3rd week of February, 20th of February. It is 20 koi dibo. We'll have it on the 20th of February. Is it okay?
It's up to him, my lord. Any date convenient to my friend.
Let it be 20.
There's a stay order also operating.
And when are you retiring?
Well, the September 26th this year. 26th of November, I stand corrected. 26th of
20th of February?
20th.
Remind us.
20th.
If it is before us,
Yes.
we'll take it out.
Happy of that. I'm very grateful.
বাকীখিনি একেটা হ'ব লিষ্ট নামটো ঠিক কৰি দিব খালি, হ'ব? Thank you. Yes.
I'm being item 16.
Lordship, in this case, I am advocating on behalf of the Lordship private respondent. So for the private respondent participants, Lordship, we have already filed our affidavit. And the important Lordship, the rule that will be played by the state government, because the state government has disclosed the
Appeal.
presentation that has been submitted by the petitioner. And interestingly, Lordship, Lordship, now Lordship, Lordship, still Lordship, the affidavit is pending.
Kindly tell us when were you appointed?
I was appointed in the year Lordship 2000.
2003. And then you were appointed as the headmaster of the school.
Yes, sir.
As the headmaster of the school, and you teach a language. Your provincialization has been as a tutor.
Yes,
Tutor. Now, as a language teacher.
So far the Assamese school is concerned, but there can be either the English teacher can be considered as a Hindi teacher, Hindi teacher can be considered as a language teacher, or the Lordship Assamese teacher, he can be considered as a language teacher. Lordship. So far my case is concerned, Lordship, as because Lordship there is no scope in the Lordship DISC code that we apply for the specific for the Lordship headmaster post. Therefore, then he must have to show as a language teacher, as a Lordship subject teacher.
True. Now there are two teachers who are teaching languages.
English and all subjects, but
Now, settled position is in law is that the senior one has to be considered for provincialization first.
that is true, Lordship.
So, who was the senior among you two?
Lordship, if you are see, Lordship, two person has been appointed on the same day, 1/1/1995. If Lordship, the petitioner challenge is to regarding the seniority. In that case, Lordship, the petitioner, the case of the Lordship, the other person who was appointed in the year 1995 on the same day as a language teacher, he has not been considered by the state government at the time of appointment. Lordship.
True, that is his headache. That is the person who was not considered. It is his headache. If he stands senior to this person, we will have him considered. But in your case, when the admitted in your case, when the admitted position is, you were appointed after him. The order which is under challenge is a simpliciter order saying that DSC did not forward him. So the SLSC and the director and the government all have worked as post offices. Whatever comes from the district level. Yes. The act does not provide for that.
So for the rule section 3 subsection 1 and clause 11, let's say X, it says that let's say 3% should be appointed as a while the Lordship the school that is to be provincialized at the time of provincialization, 3 months teachers has to be recommended for provincialization.
Yes.
But in this case, only one teacher has been recommended. And in the in the subject of social studies, Lordship, that is the petitioner as Lordship responded because he was there.
He was serving in your school.
No, Lordship.
He was serving in your school.
At that time, he was serving in my school.
My school,
Now,
yes. Now
I'm appointed in my school, Lordship.
you are in another school.
Yes.
In another school, yes. Now the provincial, when he was working in your school, and you had forwarded all the documents to the district level scrutiny committee, you must have forwarded the eligible persons.
Definitely, his name was also.
Now, if you had forwarded the eligible persons, it will not be in your mouth to say that there must be some ineligibility with him.
That is true, but when Lordship document itself says at the time of recognition of the school, whereas I was appointed in the year 2003, when the school was recognized in the year 2005, at that time the school inspector clearly stated that an advice to engage the teacher who is eligible for that post.
Yes. So he was engaged prior to you.
Yes, prior to me, but at that time he was not eligible. Lordship.
At what time?
In the year 2003 also.
In the year 2003, he was not eligible for what? Eligible for what?
For subject teacher or any teacher post, he was not eligible. That was on the.
So all those teachers, all those persons have come in as tutors. Those who do not have the ineligibility.
It was coming. When the original act was set aside by this honorable court, and the new act that has been brought by the legislature, and in that case, Lordship, earlier school was provincialized. Now the scope of provincialization of school.
We are going into some other direction, sir. We have that tendency to restrict ourselves to the facts of the case. You have been making arguments without altering any fact of the case. We are hearing you for long enough. Don't make us appreciate your silence. It will be very difficult. Very simply put, between two language teachers, who is required to be considered for provincialization?
Both have not considered. Lordship.
Both have not been considered, and you have been considered as a
Social studies teacher.
social science teacher.
Yes.
Why are you challenging him?
My lord, he's English, my lord. He
is an English teacher.
English teacher, my lord. When the my lord in the impugn order, my lord. Just for a moment, my lord, the impugn order. Impugn order, my lord.
Now we will go by the records. Yes. Where is the impugned order?
My lord will find on 42, page number 42.
Page
my lord,
number
last
42.
Last page, my lord. That is the order passed by the my lord Secretary of School Education after going through all the records that has been submitted by the director, thereafter DO. My lord, Lordship will find the table, my lord. On the table appears the
You
name
have
of
been taken on as an English teacher.
English, my lord.
And where is the order of provincialization?
Provincialization that my lord will find on page 28, my lord.
Page
Page 20 of
28.
28, my lord. Tutor, as a tutor, my lord.
So it was not on the basis of a social science or any other thing.
Yes, my lord. And my lord, so
When the appointment was made, Lordship, at that time the headmaster was also recommended as a teacher, a tutor. Only post that was recommended as a tutor because that school was not provincialized and it was amalgamated at that time. Lordship.
Shall we dispose it off?
Lordship,
We are disposing it off.
let it matter to be taken up on 7th or any
Are you appearing? Are you serving in the school as of now? Are you being paid your salaries? Then let a proper person serve. Either you or him, we do not know. But from 2024, you are not prepared. Why do you want it on 7th after we have spent 20 minutes on it? Heard Mr. B.K. Das, National Council appearing for the petitioner, also heard.
Just below the table. Dorhat has decided to recommend the headmaster as social science teacher and also in Assamese medium school. Hindi teacher is recommended as language teachers. Thereafter, this particular student was recommended as a social science teacher.
Who?
I have been.
No. As English teacher.
English
The
teacher.
table says English teacher. Where?
Fine. Subject for it English. District school teacher recommended his name as a social science teacher.
So even then it goes. Then even then it goes.
That's what
Will it not go even then? You are provincializing a maths teacher, recommending him as an English teacher. Then. Hmm.
the English teacher,
Ah.
his date of joining and the present petitioner date of joining is same.
Hmm.
This 2 point I just wanted to clarify.
But Jiban Jyoti Kakoti, is any writ petition pending for Jiban Jyoti Kakoti?
Even the English teacher, he had
Whether any writ petition is pending before us? Huh?
even the petitioner has not made
The petitioner says he should be there instead of him, not instead of Jiban Jyoti Kakoti. Is it not? If he had made any claim against Jiban Jyoti Kakoti, it would have been a different matter. And you are saying he was not eligible for provincialization. You are a BA, he is a BA. You are a DLED, he is a DLED.
No, Lordship. Lordship, to obtain Lordship BA or to Lordship take a degree of Lordship DLS Lordship,
Hmm.
he must security there.
So he does not have DLED.
Lordship, his Lordship got the DLS certificate in the year 2022.
Huh.
Lordship, I got the DLS certificate in the year.
That does not make you senior.
One thing, the second thing is Lordship that the minimum percentage that is required is 45%. Lordship to take to enter into or Lordship to take the admission as a DLED candidate.
So he forged his mark sheets.
Percentage in the Lordship higher secondary.
You have forged your mark sheets to get the DLED.
My lord?
Have you forged your mark sheets to get DLED?
No, no, my lord.
How did you get your DLED if
No,
you
my
don't
lord.
have 45%?
Oh, my lord, that is, that has been, my lord, done while, my lord, those teachers who were not completed, my lord, my lord, prior provincializations, my lord, and on, my lord, that is open NIOSs.
Or analysis.
Through analysis, all the, my lord, this, my lord, requisite qualification for the, my lord, regular candidate, who those existing teachers who are, my lord, tendering their services already in the Vansari schools, my lord, NIOS accommodate them, and my lord, accordingly, my lord, all are allowed, and they have, my lord, appeared, and my lord, he has qualified, my lord. And my lord, section 7 is there apparently. 5 years time is there, my lord, as part of software, my lord. That section 7, my lord, empowers 5 years. Even if he fails to, my lord, acquire the requisite qualification, he will remain as a tutor, my lord. 5 years time was.
Heard Mr. B.K. Das, Standard Counsel for the petitioner. Also heard Mr. D. Sharma appearing for the respondent number 6. Full stop. The respondent number 6 has filed an affidavit in opposition on the 6th of November 2024. Also heard Mr. P. N. Sharma, Learned Standing Council, Elementary Education. Full stop. The department has not filed. The Elementary Education Department has not filed any affidavit in the matter. Stop. The petitioner had earlier approached this court by filing WPC 2203 of 2021, wherein this court by order dated 19/7/2021 had directed that the effect of provincialization given by the order dated 5/2/2021 should not be given to the respondent number 6 until further orders. The writ petition aforesaid came to be disposed of on 13/8/2022. Okay. The
Because today I was not aware this matter has been listed today. Only when I got the information.
It was listed without showing your name. It was listed without showing your name. Tomorrow. At the request of learned Mr. D.K. Sharma, learned counsel, appearing for the respondent number 6, list this matter tomorrow. Full stop. Learned counsel for the petitioner shall be at liberty to, oh, tomorrow, not tomorrow. We'll have it day after tomorrow. Day after tomorrow. Day after tomorrow is what day?
Tomorrow is 26.
Then we proceed with the order. What did we write? What did we write? Was disposed of, huh? What difficulty you have day after tomorrow?
Lordship, on 30th, Lordship, I have already a fixed matter in Tanaka bench, Lordship. That's why.
Day after tomorrow, 13 again. We'll have it on the 2nd.
Yes.
On the 2nd. Matter has been heard at length. Parties are to come prepared for a disposal on the 2nd of February 2026. In the meantime, the counsel for the education department will also be at liberty to procure the records which were taken into account while passing the order dated is that
7/11/2026.
7/11/2020
2020.
23 full stop. It is observed that the respondents have not annexed any and have not filed their affidavit in opposition. And from the order dated 7/11/2023, it appears that only on the recommendation of the District Scrutiny Committee only because the District Scrutiny Committee Jorhat did not recommend the name of the petitioner for provincialization, comma, the claim for provincialization of service was rejected, full stop. Prima facie, the order has been passed mechanically without addressing the actual grievance of the petitioner, that he having been senior in the length of service to the private respondent number 6, comma, full stop. He having been nailed, he was senior to, full stop. List on 2nd of February 2006. Of like.
Lordship, I have written instruction to my that employee completed in 1 month time and return will be submitted by the end of February.
End of February. Mr. So-and-so learned counsel appears for the petitioner. Ms. N. Fukon learned counsel appearing for the respondent. Number 3 has submitted that the inquiry would be completed in 1 month time and Result will be communicated by February end. Full stop. This submission is made on the basis of instructions received by her from the appropriate, or from the respondent number 3. Respondent number 3. Is he the respondent number 3? He's a district commissioner. From the, on behalf, or not from the respondent number 3, on behalf of the respondent number 3. Full stop. Accordingly, list this matter again on the 3rd of March. No, Bondhu has said. No, February end they will have the inquiry report, right? So,
Second week.
9th of March, on which day the result of the inquiry will be communicated to this court through the through Miss N. Fukon, learned counsel appearing for the Miss K. Fukon, learned counsel appearing for the respondents. Full stop. In case such result is not placed before the court, the respondent number 3 shall personally appear before this court on the said date.
High level.
I had said N. Fukon, perhaps first time also. It will be K. Fukon, right?
In this case, the, I have filed rejoinder. In the rejoinder, they have brought certain new documents, which we need to controvert. And we have taken a specific plea in our academic composition to that effect. We can take your losses to the academic composition.
What is the
Facts
basic
relating to
challenge?
the petitioner with your lordship was an employee of the Bank of Maharashtra. Now, initially he was posted in the northeastern region, and he was in the northeastern region for last 13 years. That is on record. He was in northeastern 13 years, and thereafter he was posted in Dehradun branch, Dehradun zone. He joined there in Dehradun zone, and subsequently, without information, he came back to court. A TP was initiated. Then he was given a minor penalty after inquiry and all these things.
Why did he come back?
Now, due to medical reasons, it is a statement that it made medical reasons.
What did the DP find?
Huh?
What did the DP find? There was no medical reason.
So he gave medical reasons, but he was on leave without any letter and nothing.
Okay. Then?
Only one WhatsApp message. Now, subsequently, he resigned from service. And his resignation letter was also accepted. Now he is saying that he needs to be transferred to Guwahati.
No, I did not say that is
No, no,
not Guwahati, not Guwahati.
Guwahati zone.
Two at a time, we don't have stereo effect here.
A misstatement has to be pointed.
Guwahati zone.
We'll correct it when the matter comes back to you.
Guwahati zone, he was, Guwahati zone is in the entire northeast. Guwahati zone compares the. Now, Lordship, so far the affidavit in opposition is concerned, I'll take your Lordship's paragraph 9 and 10 for a moment. Just why I'm saying, as my lord has got it. Paragraph 9 and 10. The rest of the statements made in paragraph 6 of the writ application, the important state, the WhatsApp messages as referred to the petitioner is not annexed to the writ application. Hence, without perusal of the same, the respondent cannot give effective reply. The opponent creates plea of this honorable tribunal, submit additional affidavit if the petitioner submits the WhatsApp messages at the subsequent stage during the pendency of the writ application. Now, by virtue of the rejoinder, they have submitted the.
What WhatsApp message relating to?
Now I produce your lordship their conversation with the departmentals and the rejoinder your lordship to page 189. 190.
No. Are you supporting the are you arguing on the departmental proceedings part?
What?
No.
Because challenge the departmental proceedings also.
No, no, no.
And
We will reject his challenge to the department proceeding on the face of it. Tell us whether you could have accepted the resignation after you received a revocation from his end. That is the only issue. A man has been taken to have resigned from service. His case is, I revoked my resignation before they accepted it. If he revokes it prior to your accepting it, the resignation goes. Now, if the resignation goes, he is reinstated in service. You are not allowing him to work till now, is at your risk and cost and peril. You want to continue the DP against him by reopening the entire issue, happily do so. He will take his own, just be concise as to whether the resignation was correctly accepted. Matter ends. We do not want the reason why he resigned.
What is clear in the writ application?
Ah, yes.
What is his period? Issue a writ directing the communication dated so and so.
Ah,
Resignation. Next number 2.
rejected.
Mandamus or
Who is
any other
rejected?
writ directing the respondents to transfer the petitioner from Dehradun to so and so.
Two we are rejecting. Two we are rejecting.
No, that is on a separate ground. I'm not asking for.
For the time being, two we are rejecting. Or we will say we are not passing any orders with regard to the prayer made at 2.
Hmm.
He would be at liberty to agitate the same.
Yes.
And if the department finds it fit enough to consider his posting to anywhere. Keeping in view the fact that a mother dependent disabled Parkinson disease under the Disabilities Act, defined as a disabled person under Disabilities Act, is residing with him, and the law requires the department or any administrative authority to take that into consideration and arrange for proper medical care. If he cannot be posted in Guwahati, wherever you post him, you have to show to him that yes, this is the treatment available, this is how you'll be able to take care of your mother. Matter ends. Yeah. So we'll instate him. Yes. Where is your revocation?
Lodge.
Your revocation that I don't want to resign, I'm withdrawing it. Where is your withdrawal?
The revocation, my lords, was.
That is your prayer?
Lordship.
That is your prayer?
Yes, twin prayers, my lord. My revocation.
Just may I submit? For a moment.
Oh, yes.
Page 151.
Ah.
For a moment, page 151.
Yes. Resignation letter.
I pray you that my resignation may be accepted.
See, we will set it aside for more than one reasons. Is there any statement in your affidavit saying that after he tendered his resignation,
Yes.
he was given a due counseling that this resignation is going to hamper your entire life, sir? What are you doing? Kindly withdraw it, reconsider it. Did you do it? Settle position in law, you have to do it.
Whether the letter given by the petitioner withdrawing his resignation.
That is what he has to do. That is what I had asked him.
Yes.
Yes, my lord.
And he would be pointing out something at least.
There were two communications, my lord.
Please.
First at page 79.
Page 79.
Page 79. This is an email, my lords. This was on, my lords, 8th of May 2025.
Ah.
My lords, I am writing to respectfully request for my transfer from my current position at Dehradun zone to Guwahati zone due to unforeseen and urgent medical circumstances concerning my mother. Page 79.
No.
Okay.
This, in fact, is the first. And then, my lord, page 114.
No, this is 3rd of June. You are asking for setting aside of 852025.
No, my lord. 3rd of June, my lord, is the forwarding. Down below, my lord, lordship will see the date, my lord. Because these mails are like forwards, my lord. He's been forwarding them from time to time. Lordship will find the date, my lord. Date Thursday, 8th May 2025, 6:13 PM. This is the
PM.
Yes.
Yes.
This is my lord.
6:13 PM is again after they have accepted your resignation.
No, they did it, my lord, after 1 hour. The acceptance was communicated after 1 hour, which they
No,
could not have-
communication is another part. Acceptance at what time?
No, acceptance, my lord, their letter.
Where is
should
their
we have?
letter?
That is at page
Page
84.
Where is the letter?
My lord, 84, my lord, page
84.
84, annexure 21.
Okay.
This is, my lord, Thursday, 8th May 2025, 6:40. So 6:13 I send this, 6:40 they come up with this.
Where do you find that 640 part?
3 months.
Where do you find that 640?
Lordship, 1840, Lordship, the time.
That,
Date Thursday, 8th May
6:30.
2025, 1840. This is half an hour after this, and this is before the 3-month period, my lord, my notice period.
You are advised to immediately close it. To whom has it been written?
My lord, this is by way of a mail, my lord.
No, to whom?
My lord, to me, my lord, the petitioner.
To close your ECC account?
Yes, this is some employee.
No, where is the acceptance of the resignation?
My lord,
That
that
is at page 86. Lord.
86.
That is what-
86. Resignation application. So and so, 85. Mail was
to the zonal manager. There are. You are governed by your own rules.
What?
Own rules. Which bank? Bank of Maharashtra. Do you have any policy on how to accept the resignation? On your rules? Or which rules do you follow?
that I can get back to your lordship.
Hmm?
Instructions.
When?
Maybe on next week. Lord. I will take instruction on that.
No, if you have nothing to show now, then we are proceeding. We can give you some 15-20 minutes to find out if there is any policy
Yes,
of
that's a
the
policy, my lord. In fact, there is that exit
resignation
policy.
policy.
Yes, I have
Where is
annexed with my rejoinder.
And service condition.
Service condition is regulations are also there, my lord.
How is the resignation supposed to be accepted?
My lord, the resignation, my lord, the exit policy, if I may, is there with my rejoinder. The resignation also appears. Yes, I have annexed the policy with my rejoinder, my lord, that is at page 193, my lord. And 195 is the resignation part.
An officer can resign from the service of the bank by serving 3 months notice to the computer.
Yes, 3 months notice, my lord. My resignation is 10/2, accepted on 8/5. Before the 3 months, Supreme Court says that cannot be done.
And I award staff, the next year, honor, lordship, the competent authority shall convey the sanction and the request to the employee in resigning in writing. And award staff can resign from the service with the notice in 1 month. The control will within.
What stuff, not manager, skill 1.
Serving 3 months notice, within 3 months.
No, not within 3 months, my lord. Supreme Court says 3 months has to be complete, my lord. That is the law, my lord, laid down by the Supreme Court.
You have it?
Number of judgments. My lord.
You have
And
it?
same to same annexure, yes, my lord. I have a judgment.
Do you have the records which led to the resignation being accepted?
That is what I have to say. You have to see that. I think I know that.
Lords, one more issue I would like to point out before lordship proceeds, my lord. They have, my lords, the order, my lords, of in the DP imposing censure, which they have annexed at page 175. They have never communicated to me. My lords. That is
What? Please come again.
My lord, lordship, the order of censure in the departmental proceeding, because one of the contentions in the writ petition is that an employee, an officer against whom a DP is pending, my lord, his resignation cannot be accepted, my lords. That has to be completed, and then only he can be allowed to, because there are lots of, my lords. Now what they have done, my lords, in order to cover up their lapse, they have, my lord, predated an order of 15th of April 2025, annexed with the affidavit in opposition, which has been never served on me. my lords. I have specifically taken that stand, that this was never communicated to me. They want to make out that, yes, we have completed the DP in time, so now.
Yes, why did you accept it prior to the 3 months period?
The resignation was
It was 2 days prior, if I'm not wrong.
Yes.
2 days prior.
Yes.
Why did you accept it 2 days prior to the 3 months period being over? Order does not reflect anything.
let it come next week. Dr.
Satisfy us on these 3 grounds. What are the grounds? Yes is what? Tell us which grounds you will satisfy us on.
Regarding acceptance of on 3 months.
That is one.
Yes.
Secondly, the counseling before accepting the resignation. Supreme Court is very clear when a person resigns citing certain difficulties and not to go and join somewhere or not out of his own free will because he wants to go and enjoy the nature. Counseling.
Okay.
There may be 101 reasons why a man tenders a resignation. Some fight at home even might lead to it. So there is always a counseling required before a.
After first resignation letter, Lordship, he has given another letter.
He is totally at fault, sir. He is totally at fault. He has been a man who has lost his mind. Now you are the state. That is the whole problem. You are the role model employer. That role of a model employer has to be played. That is the only difficulty. So, whether any counseling done? Why before the lapse of 3 months when the Supreme Court says that it has to be 3 months?
That I can satisfy you, Lordship.
Two, because there I will point out another thing to you, page 195. Take page 195.
195 of the
The rejoinder. Point number 334. Competent authority may, in his or her discretion, waive the notice period.
Point number
3.3.4. Is it so?
one thing, Lordship.
Then prevailing by duly recording his or her justification or recovery of employee's salary in lieu of the notice period. Have you seen? Now that order which has accepted it does not reflect anything. So, why was it allowed? And that cannot be a simple explanation. It has to be there in the justification before the order.
Another thing, Lordship.
And the third is when he gives a mail at 6:14 or 6:13.
6:13.
Why is it? Why is the acceptance coming at 6:40, accepting it from the next day after office hours? What was the hurry? The disciplinary proceeding, we are not concerned with. The transfer, the request for transfer will only be considered to the extent, if he is reinstated, will only be considered to the extent that the Person with Disabilities Act allow caregivers of dependents to be accommodated as and where.
Dehradun is having, Lordship, as per the transfer policy which my learned friend is relying upon. The transfer policy which my learned friend is relying on, in the state transfer policy, if he wants to revert back Guwahati zone,
Then
he has to serve in the Dehradun zone because he has not challenged his transfer to Dehradun zone. He has not challenged it.
is
He has to
so
be
far
reverted to the-
as documents are concerned, sir, you are very correct. Does the transfer policy provide for caregivers of disabled dependents? It does not. So he falls in a separate class. If it has not been provided for in your policy, we will lay down something which will be in accordance with the act.
One thing more, Lordship, if I humble submission. The petitioner concern was all along in Dehradun. The GP initiated in Dehradun. Everything, the service was in Dehradun. Everything happened in Dehradun. Your Lordship, whether this writ, Honorable Court or the High Court at Dehradun has the jurisdiction.
That was supposed to be the first submission.
That is the
The Mr. So-and-so appears for the petitioner, Mr. Nandi appears for. Mr. Nandi appears appears for the respondent bank. Matter has been substantially heard. List the matter again. Matter has been substantially heard. Mr. Nandi prays for a short accommodation to answer 3 queries of this court. We are not writing down the queries. 3 queries of this court. List the matter again on.
after 2 weeks, Lordship, because I have to take it.
I'll forget. I will forget. My difficulty is I'll forget.
Well, substantially, it has been.
No, when the resignation can be accepted on email. Don't give us Dehradun.
Huh?
Don't tell us Dehradun is too far.
No. The point of.
List the matter again on, we'll give you till 11th.
One more thing, the point of jurisdiction of this. Kevin McCaffrey.
If it is taken up in the affidavit in opposition, we'll definitely consider it.
Quite adequate affidavit.
Matter has been substantially heard since the pleadings are complete. Take it down. You will not play like.
Lordship.
Sorry. If you try to play like that, then we can pass orders. Yes.
Your Lordship, there was a DPC for promotion from the cadre of, from the staff nurse to the cadre of sister tutor.
They have done it for the administrative, for the practical persons. They have not done it for the teaching staff.
No,
Or
they
that's-
have done it.
Huh.
They have done it. The issue is like this, if I may briefly, before I take your Lordship to the minutes of the facts. Now, the entry cadre is the staff nurse, wherein the diploma as well as the graduate.
Madam, we are taking it up for disposal. Prepared.
No, Lordship, because affidavit from respondent number 1 is pending, Lordship.
Who is respondent number 1? Why does he not file one affidavit?
Because matter is pending before the continuous hearing. So. that affidavit
No, I
is
don't
necessary.
understand. When he has filed a when he has filed a writ petition, which is before us, why what is the reason why an affidavit cannot be filed because it is pending somewhere?
Because there are 19
Whose affidavit?
One.
Whose affidavit?
private director.
Who appears for the respondent number 1?
Which was
Who appears? Who appears? GA Assam appears, or does the Health and Family Welfare Department? Then why are you not filing that? How can you say we are awaiting his affidavit? You are required to file it.
Yes.
Tell us the reason why it has not been filed.
Because I have not received the instructions. So Lordship may kindly allow me some time, Lordship. I'll file the.
Without that affidavit,
Your Lordship, may I just point it out?
Ah.
If I may just point out, Your Lordship, the Director of Health Service is the cadre controlling authority. He is the one who appoints us, who promotes us. So he is the one who has already filed the affidavit. So the affidavit from the government is not required, Your Lordship. If they wish to file, they can file.
at times, we have not gone through the matter in detail, but at times,
Yes, Your Lordship.
the very absence of because the directorate level and the government level are taken up to be 2 different levels. The government is government and the director is only for the directorate part. So unless we have something from the government, in fact, if you go through the rules, you will find that it is only the secretary and above level who are required to file affidavits before the court in contesting a matter. The director actually has no authority to do so. They give affidavits, we take it on record. But who can represent the stand of the government? It's the secretary or above? Is it not? Can we go by the director? We cannot, sir. It will lead to your prolongation of your agony when they go up.
Let her file.
Mr. Rana for the petitioners also so appears, Ms. D. Boral and council appears for the health department and has prayed for an accommodation to file the affidavit on behalf of the respondent number 1. The learned counsel for the petitioner has pointed out that an affidavit by the director has already been filed, and that substantially would be sufficient to decide the dispute in the matter. However, on the prayer of Ms. Bora, list this matter again on. By when can you file it, madam? 3 weeks. 19th of February. You should have said 4 weeks. 19th of February 2026.
Your lordship, can you?
3rd of February. Yes, yes, yes.
23rd of February 2026, by which time the respondent number 1 shall ensure the filing of the response to the writ petition, failing which the matter will be taken, matter may be taken up for consideration on the affidavit filed by the
Your lordship, their filing of, my
Director.
respected senior is filing on 23rd. The matter is fixed on 23rd. If they can serve us the copy by 20th, at least 1 or 2 days before. If required, I'll file it or I'll argue on that.
and that will help expediting the case.
Let it be.
The learned counsel for the respondent number 1 shall endeavor to file the affidavit at least 2 days prior to the next date of listing by serving an advance copy to Mr. Sinha, who shall also be at liberty to file his response to the same if so required.
Deeply obliged, your lordship.
May it please, your lordship.
Yes, whether entitled to compassionate family pension? Madam? Compassionate family pension?
This is to demand some till last subject. So,
Yes. Department of Health in the Dima Hasao. Kindly tell us. She's here, she's here. She's here. Yes, tell us. To the Accountant General. Who appears for the Accountant General? You appear, sir? They forwarded it to you. Do you have a copy of what you have forwarded? Yes.
Your lordship, I file additional affidavit concerning what you forwarded. I file additional affidavit also.
It is there here.
Yes, it's there.
Did you serve a copy on the Accountant General? Yes.
Sir, last time when I filed.
Is it?
Yes, yes. I'll serve copy.
Did you? You are not served with a copy?
I think I've,
Huh?
served.
Senior GASC AG. Someone has received it. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned standing counsel appearing for the health department. Miss, huh? Miss so-and-so for the Dima Hasao council and Mr. S.K. Medhi for the respondent number 6. The Learned Counsel for the petitioner has referred to the additional affidavit wherein from where it appears that the Joint Director of Health Services, Dima Hasao Haflong, had forwarded all the required documents in respect of the petitioner for grant of compassionate family pension to the Accountant General within bracket A&E, Assam Beltola, on 21/2/2025 by communication number. You will have to help us, sir. Tell us the number.
E/22 hyphen your lordship 2 and slash again and 2024 hyphen 25 slash 009.
1009. 1009 full stop. The Learned Counsel appearing for the Dima Hasao Council has also submitted that the said document has in fact been sent. There is another document on record by which the petitioner was requested by the Office of the Accountant General within bracket A&E Assam to take necessary steps by sending certain documents which are referred to in the letter dated 8th of December 2025, full stop. The petitioner was required to submit the following documents by the said letter. Page 35, I have given a star mark, 1, 2, 3, 4. Yes, have you submitted them?
Yes, because
The requisite documents have been submitted by the petitioner
Yes.
on, have been submitted by the petitioner.
3 letters were already issued, your lordship. Similar letter earlier.
No difficulty, you have given these documents?
Yes, I have submitted. That's why I have approached this honorable court.
And where is their receipt?
Yes, sir.
Full stop. The Learned Counsel for the no. Liberty is granted to the Learned Counsel for the petitioner. Yes, Mr. Petitioner, kindly listen to what we are doing.
I apologize.
Or you both of you discuss it outside and finish it.
Page 36, Page 36, the letter is 21 to 2025, earlier.
What did I say?
On that page,
No. This is an additional affidavit.
It is in the additional affidavit. We'll get a copy. The Learned Counsel for the petitioner would be at liberty to call for the documents requested by the letter dated 8/12/2025 and supply a copy of the same to Mr. S.K. Medhi, Learned Counsel appearing for the AG, who shall take the pain to forward the same to the Office of the Accountant General. Full stop. List this matter again on. How much time would you require after this?
17 independent
On the list this matter again on the 20th of February 2025, on which date Mr. Medhi shall apprise this court as to the stage of processing of the case for compassionate family pension. Full stop. The Learned Counsel for the petitioner shall supply a copy of the requisite documents to the Learned Counsel appearing for the AG within 5 days. Can you do it in 5 days? The same documents, you give it to them again.
Yes. I'll supply your lordship today.
Within 5 days.
Today itself I'll supply.
And on?
Before second February,
He's giving it today itself. Yes.
Oblige, your lordship.
34.
My pleasure, Lordship. The matter relates to the provincialization service of a drop teacher, Lordship. His name was dropped due to showing in the enrollment of students 4 instead of, Lordship, 10. Later on, report was called by the from the Assam Higher Secondary Education Council. But it was reflected that his enrollment was, student was, more than 4, Lordship. And
More
we have
than 4 is not going to help. At least how much do you need?
13, 13.
How
13.
much do you need? 10.
As per act, it was 10, Lordship.
It was 10 and you had 13.
Yes, Lordship.
Yes.
Later-
Secondary education. Get someone from the secondary education. After something.
35.
May please, Your Worship. My lord, the notice of motion was issued, my lord, on
You are praying for taking into
Pension.
account the past
Yes,
services
yes.
and grant you pension.
yes,
Whereas you have been provincialized under the Act of
not
2000?
provincial, not provincial.
You told.
My
Have
lord,
you wrongly
because
read?
I was initially appointed in 1989, my lord,
Ah,
provincial school, my lord.
okay.
And
Where you could not have been appointed.
No, my
Okay,
lord.
then
No, my lord. Then, my lord, my service was terminated in 1992, 18/5/1992.
Ah.
That has been challenged before this honorable court, and this honorable court set aside that termination order directing to reinstate me. And subsequently, my lord, I have completed my junior basic training. Again, my lord, the salary has been stopped in September 2007. I approached before this honorable court. This honorable court directed to release the salary. State has filed review application that has been rejected.
who
Now,
filed that review application?
my lord.
Who was the council?
Oh,
Who was the council who filed it?
my lord, no lordships are not there.
I was
No lordships are not.
Ranjan Rekon. Then
And then, my lord, in 2021, my lord, they have accommodated me as tutor, imposing a conditions that I
Ah.
cannot claim past service.
they accommodated you.
Yes. Page
You are
the
different. Okay, my bad,
58.
huh? Then
imposing a conditions that I cannot claim past service.
past services, yes.
That
These
is,
kind of matters have been
my lord, similar matter fixed. my
decided.
lord, Second of
No,
this
decided.
month,
Not decided, sir. Second,
my lord.
Mr. Ashamal and the council appearing for the petitioner has submitted that similar matters are listed on so and so. Miss, your name? Your name?
Lordship, Ashama on behalf of Vishama.
Yes. For AG and Mr. B. Talukdar, Learned Council appearing for the Elementary Education Department has submitted, no, has have endorsed the submission. List this matter again with WPC number
4952 2023,
2023
4947 2023, and 4950 2023.
on the second of February when such cases are submitted to be slated for listing.
Item 26.
This is against dismissal from service, so the records will be necessary.
Second time, my lord, we'll be filing an affidavit, my lord, a consolidated affidavit. That, my lord, will give us 3 weeks.
When were you dismissed?
My lord, on my lord, 30/11/2024, my lord.
Verge of your retirement.
Yes, my lord, just before.
Thing also passed, my lord. They have appealed, my lord. So that appeal has been
That's all been dismissed, my lord.
against the appeal, they have come, my lord. Previous to this, my lord, there was another litigation, my lord. He was listing, my lord, and that particular appeal, he appealed against that particular order.
It was, my lord, I prayed for early disposal of the appeal, my lord, that was disposed of.
That appeal was
Now, my lord, that's been, appeal has been dismissed, now I've come before the lord.
against the appeal.
Where is the charge sheet?
Lord, page 43, my lord. The allegation is that, my lord,
Arrested. Allegation is
what had happened, my lord, we had gone to serve a notice. notice of a partition proceeding. And one dead person, their number of pattadas were there. One dead person received the notice, he couldn't identify that person. That's why this entire thing started.
From where are you saying all these things?
This is actually, my lord, in the
From where are you saying all these things?
it is not there in the show in
Then-
the charge sheet, my lord, but
Then, if the charge sheet there is nothing, then why are you waiting for records? The charges are not specific.
not specific, my lord.
It does not relate to any particular incident. No time, date, nothing.
Nothing.
List of documents, they are saying list of documents. What is it? What is there?
In fact, there is no list of the list
Letter
of
dated so and so and letter received. List
Yes.
of
it's basically the complaint, my lord. The police
list of witnesses is Joyshankar Wari.
and the 3 witnesses examined, my lord. Only one
How?
witness's name.
There was only one witness.
Only one witness's name.
How could 3 be called for? Huh? Who? You dismissed the appeal, did you not? Then? See, a man of 60 years, we'll keep it for the next 5 years. He will be without pension. 5 years later, he gone, his son comes and says, this case is allowed. Then what happens? Who gets the pension? Nobody. When? When?
Because it's come to the first time in second time.
Huh?
Came was P12 had come in first time. So that's the second
Lucky for him, there is no second dismissal. First time, second time, kya hota hai? When? 2 weeks. What would you have by then? The records or the affidavit? Who dismissed you? Some other department?
The deputy commissioner, deputy commissioner, my lord.
Who appears for the deputy commissioner?
government advocate, sir.
It is not shown in the cause list. Item কিমান এইটো? দিয়া আছে. Heard Mr. M. Datta, Learned Counsel appearing for the petitioner. Also heard Mr. A. Fukan, Learned Counsel appearing for standing counsel for the respondent number 1. None appears for the government. None appears for the respondent number 2 and 3. Full stop. The challenge in this writ petition is to a departmental proceeding, following which the petitioner stood as petitioner services were terminated. Full stop. The Learned Counsel for the respondent number 1 on the next date to produce the relevant records on the basis of which the appeal stated to have been filed by the petitioner has been dismissed. Full stop. The respondent number 2, 3, and 4 shall produce the records of the disciplinary proceeding held against the petitioner on the next date fixed. List again on 13th of February 2026. Full stop. Copy of this order. Yes, you are appealing for. I don't understand. You will bring it. Why was no one here when the matter was called? Government advocates are having two heavy benches. There is some dearth of government advocates in appearing in this court. To cut it. None appears for the respondent number 2 and 3. Mr. So-and-so appears for the respondent number 2 and 3. Huh? The proceedings, the records of the disciplinary proceeding to Heiko Dilune shall be produced. Last line to put some. Full stop. It is observed that the petitioner had been terminated at the fag end of his service when he was nearing its date of retirement, and therefore the Learned Counsel for the petitioner has expressed an urgency in the matter. Full stop. It is made clear that the respondents may file their affidavit on or before. Key date dilu next? 13th February, on or before 11th of February 2026. Full stop. The matter shall be taken up for consideration on 13th of February 2026 on the basis of records which will be produced by the learned counsel for the respondents, full stop, absence of records on the aforesaid date.
Okay.
The matter will be taken up for consideration on the basis of materials available on record.
To apply the lordship.
Matter is fixed today for consideration of interim order, my lord.
My lord, if I may.
By order dated 17/12/2025.
My lord. My lord.
When did you receive it?
My lord.
When did you receive it, sir? Today? Yesterday?
Part of.
Huh?
My lord, in this case, what is happened, I'll be candid, my lord, and without affidavit, I was not thinking. My lord,
Yes.
here, there were two, corollary forums were there before the petitioner to approve. So petitioner is an IIT professor. As per the IIT professors, the disciplinary proceeding which is there, he will start with very serious sexual,
Harassment offences.
and ICC was formed. After ICC, departmental proceedings were carried out. And punishment of compulsory retirement was given. My lord is aware that compulsory retirement is not in penal.
Unless it is preceded by a disciplinary proceeding. Yes.
Yes, sir. So what is happening, my lord, here this is that as per IIT statute, it provides for an appellate forum also. After the disciplinary proceeding is over, he preferred an appeal before the President of India. That appeal is pending as per the my instruction. That appeal is pending.
When did you file that appeal, sir?
That appeal has been filed, my lord. My lord will find.
30/11/2024.
30/11/2024. He approached this court in 2025. Yes.
After the filing of the appeal, my lord, the appeal, the instruction has been given to me by the IIT is that the copy of appeal was not given to IIT. That the appeal is still as of now pending. So they are approaching here, my lords, the same grievance to the two separate forums. One is this Honorable High Court under 226 and another.
Why don't you write a letter saying that I have approached the High Court? I'm not interested in pursuing this appeal. Matter ends.
That is what has happened now, my lord, in this case. My lord, my instruction, that's what my lord, we be allowed to file our affidavit.
Yes, that we can allow you.
My case is today.
When were you retired?
No, my case is now is before this honorable court, before your lordship, is this different way. But if the departmental proceeding is cannot stand scrutiny of law,
Then
that cannot be. Because of that, the respondent authority, particularly the departmental inquiry, my lord, first, my lord, internal inquiry is treated as a preliminary inquiry. It
Yes.
cannot be treated. Because of that, the Honorable Supreme Court clearly stated, and last occasion, your lordship, by order dated 17/12/2025, my lord, there is clear, my lord, that it stated that
After the ICC full-fledged inquiry was not held.
cannot, my lord.
My lord,
Since the internal inquiry committee submitted report, next departmental proceeding cannot stand.
Cannot be held,
Cannot be
yes.
taken because.
Yes. So
Because of that,
only on
this is
the,
the final, my lord, as per honorable.
so now once it becomes final,
My lord.
some order has to be passed on the report of the ICC.
Yes, they issued the departmental proceedings, charge sheet was issued, WS file, thereafter they issued person's penalty. It cannot, my lord, that go, my lord, honorable.
It had
Supreme
to
Court
end
said.
with the ICC.
If the entire proceeding is go,
The ICC's report is the final report.
my lord,
The ICC had to do it in a manner in which the departmental proceeding had to be done.
my lord, that ICC has done it. So ICC recommendations are at page number 81 to 83.
81 to?
I do not want to travel to the report, lord. This 81 to 83 is the recommendation. It starts from the page number 68.
the internal report committee, my lord, report, page 68, my lord, annex of 4, my lord.
Starts, the recommendation, my lord, will find it page number 81.
Hmm.
The first recommendation is the interim measures, my lord. That is at serial number D, my lord. That as per the sexual harassment at women at workplace, the such act, some interim measures have to be taken responding to an email letter circular, IC chairman directed HOD department to allocate a different.
In any case, when
Then the
can you?
recommendations, my lord, the first recommendation.
The internal committee recommends.
There is no first, second, third. Report is report.
My lord,
And they have to, departmental
I-
authority has to pass an order on the basis of that penalty, pass on the basis of that. It cannot go to the departmental inquiry again, search, it cannot, my lord. Honorable Apex Court clearly stated.
until unless, my lord, that inquiry does not help him to be not guilty. If the ICC report says about a departmental inquiry, or if my statute, if the departmental proceeding which is there, foresee the departmental inquiry, my lord, my humble submission is that maybe the IIT was justified to complete that departmental.
You were
There is
given
a
an,
act.
you were
First-
given the opportunity.
The act cannot go
Were
beyond.
you given the opportunity to cross-examine
Yes,
the
my lord.
witnesses? And then I was talking to him, sir.
Aye.
I'm not setting aside the penalty proceedings today.
Yes.
Kindly have patience. That is the art of the court. It is not about speaking in the court. It is about listening, observing, and then making a statement. Have we, till now, have we put anyone to a disadvantage?
I'm sorry.
Then we need a discussion today so that on the next date we can do something in the matter. You understand me, I understand you, we can do something in the matter. Hold your breath.
Run at a time, no, my lord.
Rein your horses for a time being. We are not at war. Mr. Bora,
My lord,
in the ICC, were you given
my lord.
the opportunity to cross-examine and everything?
Everything is there, my
All
lord.
opportunities
Problem
were
is
given.
that, my lord.
Again, you are letting your horses run now. You were given all the opportunities during the ICC.
Aye.
Then they gave you another charge sheet. Then they held another proceeding.
Yes, my lord.
Again giving you all the opportunity.
Yes, my lord.
And then they have issued the termination order. Understood. I have understood the fund.
My contention is that
He will require an affidavit before you open your contention.
required.
So far, it is your argument that a man will not be tried twice. We understand that. He was tried once by the ICC, then he was tried by the DP. Is it not? You are saying you will not be
I
tried
said
twice.
this on the basis of first inquiry was conducted on the basis of that act.
And that is
And
supposed to
they
be the
have
final
passed
report.
an order. This is the final as per Apex Court judgment, my lord.
When
We
can you
cannot
have your
go, my
affidavit and a
lord.
record? How much time?
But 2 weeks.
We are liberal. You can have 3 weeks.
My lord.
You can have 3 weeks. But we will take it up for disposal on the
My
next
lord, my lord.
on the next date.
Fine.
It is for admission, is it not?
Yes.
Last occasion, there is a specific,
Huh?
it is for interim pair. So, my lord, that.
Interim pair of what?
For stay, my lord. Because of that, I have no service, my lord. They given the voluntary retirement.
A little far-fetched.
So since the Honorable Apex Court clearly stated is the judgment, this cannot go beyond that.
Wait
That
for a month more.
Lordship. I
Wait
cannot
for a month more. We will observe that.
My lord.
Heard Mr. Enver, learned counsel appearing for the petitioner. Also heard Mr. Swenson, learned counsel appearing for the respondent number. Mr. B. Chakraborty, learned counsel appears for the respondent number 1 CGC. So we'll require your assistance, sir. No, not on that.
Otherwise, they are the major defender.
On the question of whether the ICC report is final or can he be subjected to another inquiry when there was already a full-fledged inquiry? Because if we allow 2 inquiries to proceed, the difficulty is if we allow 2 inquiries to proceed, ICC holds him guilty. Some stroke of luck, the DPC holds him not guilty. On the same incident, we will have 2 different reports.
The punishment is one only.
It will that ICC finding is a finding in law, a correct finding, unless challenged. Now the DP finds him not guilty. The department inquiry, the other one. So he will have this will be the law once we lay it down. We'll say that when two inquiries are allowed, then in other cases there will be 2 inquiries all the time. Our order has to keep in mind what can happen. We cannot restrict it. In cases like this, we cannot restrict it to the particular case. Say the ICC says that if the ICC inquiry is taken to be final, he will only have a chance to contest the punishment given.
If the first inquiry.
But if it is 2 disciplinary proceedings, one by the ICC, one by the, then we will also be giving a handle to the accused to influence it in the DP. That is what the Supreme Court has said. Medhal Kotwal Lele, yes, there are other judgments which says that there will be no two proceedings. One proceeding, finish it. He'll challenge that if necessary. Why the second one? If the second entire inquiry goes, the best relief he has is consideration of the ICC report, pass an order on that.
That because of that problem is that ICC report is illegal because the constitution of the committee is not on
And that we will come to later on.
That is also challenged.
That is where you will challenge it.
Yes,
that you
or
will
at
take a
at the
challenge to
time
that
of
later
reply,
on,
I
not
also.
as of now. So is this matter again on? It is your affidavit.
No.
March or the first.
February, well, any date. No, March is too late.
6th of March 2026, by which time the respondent number 225 will ensure filing of the response to the writ petition, full stop. The learned counsel for the respondent number 225 shall requisition or the entire records leading of the ICC and of the inquiry held by the ICC and the disciplinary authority. Huh?
Disciplinary authority.
What about the ICC?
Same, we will produce both the records.
The ICC and the disciplinary authority. On the next date fixed, full stop. Since Mr. Bora has pressed that this matter was fixed today for consideration of the interim prayer, an attempt will be made to consider the matter on 6th of March 2026.
March will.
Mr. Khatoni, are you appearing in this matter? They say it is less enrollment. Field report says it is correct enrollment. Then what to do? Do you have the file?
Yes, I have the file.
If you have page 42, which is your school, madam?
Lordship,
Page 42 on which is your school?
this is the report of the independent authority, Lordship.
Ah,
Where the petitioner name was appeared in serial number 47.
at page number
Page number,
53.
yes, Lordship, 53. It was specifically written as the early 10 remarks, Lordship.
So there is a 53 page number. Oh. He requires 4. He requires 10. He has got 11.
Yes,
Is
sir.
that not? Yes. Yes, when can we have it, sir?
Press report is called from the Assam State Education Board, madam.
Assam State Education Board. The government does not believe what the director has forwarded.
The director has called for a press report from the board, madam. And we are
Just
here
a minute.
for a report, madam.
No. This statement which has been made This report which has been given by the
Independent authority, Lordship.
later as per the report obtained from the ASEC. Can you see? That ASEC has become that Assam
Yes,
Education
yes,
Board. Why?
same. Now they have corporate this board.
Have you made the ASEC a party?
No, Lordship.
Regarding enrollment, they are the authority who can give the says enrollment. How many students have applied?
Miss, you are, your name's madam?
P. Sohoria, Lordship.
P. Sohoria, Miss P. Sohoria, Learned Council appearing for the petitioner has drawn attention of this court to the report annexed at page 53 of the petition, by which it reflects that as per the report obtained from the Assam Higher Secondary Education Council, enrollment in the school of the petitioner for the particular subject for consideration of the petitioner for provincialization was 11. Full stop. The said report had been forwarded by the District Commissioner Majuli to the Director of Secondary Education, who had in turn forwarded it to the Office of the Government in the Secondary Education Department. The communication of the Director of Secondary Education dated 19/2/2024 has referred to a joint committee for provincialization service, which had required a re-verification at field level by the independent authority. And the Learned Council for the petitioner submits that the report annexed at page 53 of the writ petition is the report of the independent authority. Full stop. Today, Mr. N. Khatonia, Learned Council appearing for the Education Department, has submitted that the director has again called for a report from the Assam State Education Board, Division 2 by communication dated 30/12/2025. Full stop. The list this matter again on 20th of February 2026, on which date the Learned Council for Learned Standing Council shall apprise this court as to the outcome of the inquiry inquiry which was requested by the Director of Secondary Education. Full stop. If the concerned board was a party, you would have directed them. Yes. Yes, sir. Huh? Then pass the order. What was the order we had proposed to pass? I forgot.
I have taken the instruction from
Hmm.
they are processing the file of the petitioner.
For provincialization. Yes. Click here, heard Mr. R. Sharma, Learned Council appearing for the petitioner. Heard Mr. R. Sharma, Learned Council appearing for the petitioner. Also heard. Yes? You take down the attendance. But so and so, so and so, so and so. This writ petition had been preferred by the petitioner, being aggrieved by the order dated 29/2013, issued by the Director of Elementary Education, Assam, and with prayers for directing the respondent authorities to allow the petitioner the benefits of the provincialization as an assistant teacher of Sonapani Sarbojanin LP School, Udalguri. Full stop. It is the case of the petitioner that the petitioner had been granted the benefits of provincialization in service by an order dated 16/5/2013 under the erstwhile Assam Venture Educational Institution within bracket Provincialization of Services Act 2011 as amended in 2012. Full stop. On such order being passed, one Chittaranjan Sharma had approached this court by WPC 3837 of 2013 and by order dated 16/7/2013 this court had directed that the provincialization benefit should not be granted to the petitioner herein until the next returnable date. Following such an order, the Director of Elementary Education, Assam, had withdrawn the order of provincialization granted in favor of the petitioner in the Sonapani Sarbojanin LP School. Full stop. The order reflected that the withdrawal was done in connection with the High Court case in WPC number 3873 of 2013 filed by Sri Chittaranjan Sharma. WPC 3837 of 2013 came to be disposed of on 8/1/2018, directing the petitioner therein to approach the appropriate education tribunal for redressal of his grievance. The same order had also observed that the interim order passed earlier on 16/7/2013 stood merged with this order. Full stop. The petitioner, not having been granted the benefits of provincialization even after disposal of WPC number 3873 of 2013, he filed a representation before the Director of Elementary Education, Assam, Kahilipara, praying to be afforded the benefits since the writ petition no longer survived and the interim order had already merged into the final orders passed in the writ petition. Full stop. When he was not given any benefit, the petitioner approached this court with prayers as mentioned herein before. Who is this respondent number 10? The respondent number 10 in this writ petition, who was the petitioner in WPC number 3873 of 2013, had filed an affidavit in opposition whereby a statement has been made that he had preferred Educational Tribunal case number 1 of 2018 before the Education Tribunal, Udalguri, and the writ petitioner had also been made a party thereto. This affidavit was filed on 8th of February 2019. Full stop. The petitioner has filed an affidavit in reply, whereby he has brought on record the order dated 15/6/2023, by which the litigation initiated by the respondent number 10 in this writ petition was dismissed for default and disposed of. It is stated at the bar by Mr. R. Sharma that no appeal or restoration of the aforesaid dismissal has been brought to the knowledge of the petitioner in this case, full stop. Next para, the learned counsel appearing for the petitioner has submitted that this court had directed that the benefits of provincialization in favor of the petitioner be kept in abeyance only during the pendency of or only till the returnable date in WPC 3873 of 2013. And it was an arbitrary act of the Director of Elementary Education to have withdrawn the entire order by which the benefit of provincialization was bestowed upon the petitioner, full stop. He has submitted that it would have been another case had the order of provincialization been kept in abeyance till the disposal of the writ petition. However, the respondent authorities hurriedly had withdrawn the entire provincialization, which was not, which does not appear to be the intent of the order dated 16/7/2013, passed in WPC 3837/2013. He has further submitted that in any case when the writ petition had been disposed of without granting any of the prayers made by the petitioner in WPC 3837 of 2013, and the interim order passed earlier stood merged with this order, it was incumbent upon the respondent authorities to have revived the order of provincialization passed in favor of the petitioner on 16 May 2013, full stop. The learned counsel for the petitioner has further submitted that the litigation before the Educational Tribunal also having now brought to a closure by the order dated 15/6/2023, the withdrawal of the benefit of provincialization from the petitioner needs interference of this court, and the petitioner deserves to be bestowed the benefits of provincialization from the date on which it was originally bestowed upon him, granted to him, full stop. He has accordingly prayed that the order dated 2010? 20 September 2013 be interfered with, and the petitioner be given all the consequential benefits, full stop. The BTC has not filed any affidavit in the matter, full stop. The Education Department has also refrained from contesting the matter on merits by filing an affidavit in opposition, full stop. However, the learned standing counsel appearing for the department has submitted that the facts which are evident from records is that there were no orders to withdraw the benefit of provincialization from the petitioner, and it is also a fact as available in the records of his case that the Educational Tribunal has also dismissed the litigation initiated by the respondent number 10 herein, full stop. He has also submitted that the department has now started to process the case of the petitioner for restoring the benefits of provincialization upon him, since no litigation now survives regarding the grant of benefits of provincialization upon him. Next paragraph. Having heard the learned counsel for the petitioner, and the learned counsel appearing for the respondents, this court sets aside the order dated 20th of September 2013, which was passed only on the basis of an interim order passed by this court, even though such interim order did not require the withdrawal of the benefits of provincialization, full stop. Although all litigation regarding the provincialization of the services of the petitioner had come to an end in the year 2023 itself, the petitioner is yet to avail the benefits of his provincialization, full stop. In such circumstances, this court directs the state respondents, more specifically the respondent number 1 and 2. Anybody else is to do it? 1 and 2. BTC has got nothing to do it, no? 1 and 2. To expedite the processing of the 1, 2, and 4. To
4, my lord.
1, 2, and 4 to expedite the processing of the file of the petitioner for restoration of the benefits of provincialization granted to him by the order dated 16/5/2013, full stop. The respondents would be at liberty to make enquiries after restoring the benefits of provincialization upon the petitioners. The respondents would be at liberty to calculate the financial benefits which may have accrued to the petitioner in case he continued to render his services despite the withdrawal of the provincialization order, full stop. It is made clear that this court is not making any observation regarding the entitlement but has left it to the inquiry of the respondent authorities. Writ petition disposed of. No costs. Or should we impose some costs? No.
Obliged, my lord.
Yes.
For my learned counsel, I think in the system lordship in this language. Item number 58. And 57, my learned counsel here. Here the case is by the day one provincialization of their service. That is item number 57. Right. And 58 whether they have challenged the proposal of provincialization. Provincialization.
Not me, your lordship.
No. Proposal of provincialization that challenge, particularly respondent number 8 to 11, whom I represent. The proposal, my lord, out of this, my lord, 1% has been provincialized. The respondent number 11.
Where is the proposal, sir?
Proposal is that. Proposal is that. Page 28.
Page 28 in WPC 98.
WPC 98 is lordship at 20, page number.
20,
It's a
okay.
recommendation, your lordship.
Yes. This Catholic Mission ME.
It's last row, your lordship, 30, column 11, your lordship.
Catholic Mission ME, Koliabor.
Lordship,
That is a school.
that is a school.
Yes. Ranjit Hazarika.
Respondent number 8, 9. The lordship is better. Page 28. Down below.
I see.
Burua. ইখন দিয়কচোন এই চাৰে চাই থকাখন দিয়ক
Concord Roy is there.
yes.
Class.
Yes.
And level is page 29. So out of this one of 11, respondent number 11 has been provincialized. Proposal is not acted upon because initially the petition was dismissed on the ground that minorities, they are not entitled that the benefit of provincialization.
Unless they come up on their own.
No, on their own. It's on their own. And the review was announced. So that is how the petition has been restored. Now what I propose is So on the basis of this proposal, one school, the respondent number 11 submitted the provincial lines. An order.
Do you have the records of the review?
What's the big-
We will take it up on Monday next if it is convenient to you. Kindly have your assisting counsel find out if we were somehow connected with the review. I suddenly remember the facts where there was a Catholic school which was provincialized and thereafter, is it so? I was somehow connected. I remember you also in that. I was connected. This Catholic, I was connected here somehow. Either I have appeared or I have.
Nothing has appeared.
I appeared in the review, sir. List before a bench without me. It is only the facts which made us remember what to do. You should have told us, Mr. Alam, at the very beginning. Those who were provincialized, they had come up for a review saying that our provincialization should not be affected, something like that. Huh.
I was thinking, my lord, since the provincialization order has not been challenged,
Mm.
so therefore, my lord, it is a different case, and the proposal has not been acted upon. Let it be acted
Premature.
upon by the appellate.
Premature.
Tribunal is there. And that's what my submission would have been.
But in any case, since I was,
So
let us
otherwise, the
not.
matter is pending since 2013.
But I cannot even fix a date on this.
No,
I cannot do anything on this. No, I've simply said on a bench without me. That is the maximum I can say.
59.
Hmm.
May I please, Your Lordship, can I go through the last two order, Lordship, 25/9/2025 and 4/11/2025, Lordship. Honorable Court directed the respondent number 4 to file an affidavit, Lordship. But respondent number 4 has failed to file the affidavit till date, Lordship.
Yes, madam, for the BTC. Huh? Anybody below you has been appointed?
Lordship, already appointed, Lordship.
People who have scored lesser merit than you have been appointed.
Yes, Lordship. We are just been separated because Supreme Court has declared NIOS degree DLED is invalid initially. After that, subsequently hold to be valid by the Honorable Supreme Court and
That review, there were 2-3 reviews, MPs, yes. Then
Lordship, Honorable High Court be also treated as valid recommended. Lordship. So we need appointment, Lordship.
So yes, when can you have your instructions, madam? Give us a date.
After 2 weeks.
After 2 weeks. 2 or 3? 3 weeks.
Lordship, last week of February, Lordship. Any date last week of February.
When was your selection? 2024 advertisement.
Yes,
Select list, where is the select list?
Select list, Lordship. Annex 9, Lordship. Page number 446. 7/3/2024.
What, Mr. So-and-so, you are Mr. A.T. Sarkar.
S. Hussain. S. Hussain.
S. Singh. Learned Council appearing for the petitioner also heard. Ms. So-and-so, Learned Council appearing for the BTC. Full stop. The Learned Council appearing for the BTC has prayed for an accommodation of 3 weeks to have her instructions in the matter. Full stop. The Learned Council for the petitioner submits that the petitioners were denied appointment even after being meritorious and after having been selected only on the ground that their DLED certificates were in question before the Honorable certificates issued by the NIOS regarding DLED were an issue, were in issue before the Honorable Apex Court. Full stop. He further submits that the issue has now been settled and there is no impediment in the respondents offering appointment to the petitioners who were selected under the process. Full stop. List the matter again on 3 weeks of issue due. 6th of March, 2026.
Schedule 60.
May it please the Lordship.
Hmm.
Lordship will kindly peruse the order dated 12/12/2025. For
How much?
12/12/2025, 12/12.
You are still in 25.
Yes, Your Lordship. Last part of the order. Their direction was given to the PTC council to file a short affidavit was called for. Subsequently, on the next date also, if your Lordship takes up order date 21/2026. 21. Some time was sought for.
No, what had happened is you had your DLED from the NIOS and you are required to submit proof of being in service prior to the date of
10/8/70.
during that you were in service at that
Yes.
period of time.
Yes. So we
You
have
don't
some-
have the certificates.
we have the UDIs.
Then
Lordship will kindly for a moment.
why the UDAS? Why don't you give the certificate that you were serving?
Annexure 8/145 for a moment, Lordship.
Hmm.
This clause F. Clause F says UDIs records as a proof that the applicant was in service as on 10/8/70.
Page
Page 145. Annexure 8.
145.
That is the notification which the state government has relied.
UDAS records.
Yes, Your Lordship. Point F.
Seen.
UDIs records as a proof that the
You have
applicant-
given the UDAS.
Yes. Now Lordship will kindly take up annexure 1. There Lordship will find the details. Page 27. Page 23 starts. Page 23 starts, annexure 1.
Hmm.
Relevant portion is page 26. Page 26, topmost part on the right column.
Hmm.
Lordship will see teacher 4, Ashok Narjari, is P1.
Hmm.
And down below, the middle part, Lordship will see date of joining in service. That is Lordship will mark 1/1/16. So that is my case.
Date of joining the present school? 1/1/18. Where were you before that?
Date of joining in
From
service,
16 to
1/1/16.
18, where were you?
That is a date, Your Lordship. Date of joining in service, 1/1/16.
Where? Because in the school you joined in 2018 in the present school.
Present
From
school.
16 to 18, where were you?
I was in school,
Which school?
SN Academy.
Where is that?
That Lordship will find at page.
You had to be in service
Yes, I was
in the year 2017.
17. Yes.
So you joined service
Date of joining in service, 1/1/16.
1/1/16.
Yes.
And then you joined this school in 18.
Yes.
So from 16 to 18, were you there in 17 is what we want to know. Show us something with 17.
This UDIs itself shows that I was in service. This is
Where?
the UDIs record.
Where?
This UDIs is a government record.
It is not a government record. It is something that you put into the website.
No, I don't put it.
Oh, yes. The information has to be,
The principal.
the information has to be given by the principal or
Yes,
someone.
absolutely.
Yes. Now you joined the school in 18.
Yes.
How did the principal say that you were there in 16?
I
Whether you were in
joined
service or
School in 18.
Huh.
I was there from 16.
there is where?
That Your Lordship will find.
It will not work if you were here and there. You should be in some school.
This,
Don't make it here and
Annexure
there.
7, page 119.
1/1/9.
9. That is my first appointment letter.
Hmm? You are the same person.
Yes, yes. P1, Ashok Narjari.
1/1/16. Then
Then the other one. Then
no,
52
this is where you are asked to join.
Yes,
Where did you join?
there I joined.
Where is the joining report? Where is the certificate from the school saying that yes, he was here till 18? Hey, Mr. Monto, you know what we will ask? You know what we will ask? Give us any document to show that you were there in 2017.
No, Lord.
We'll finish it off.
No, Lordship, the thing is there, the UDICE record is there. UDICE
You
show-
guys record is there that you were working in a particular, so let us be very clear, let
Yes.
us understand each other. 2018, you are in A school. You joined your service in the year 2016.
Yes, yes,
2016, you are giving us an appointment letter.
yes.
Now 16, a client approaches you to file a case. He does not give you the wakalatnama. Can you say you were in the case? No. You cannot say so. Just like that,
I agree.
the appointment letter is there.
Yes.
You don't have a joining report.
But the UDICE.
You don't have, the UDICE says from 2000, on 2018 you were on job.
But the date of joining in service is there, Your Lordship. But taking, for argument's sake, if my learned friend comes up and says, because the instruction was sought for them,
He will not say anything. He will say 17 ka document nahi hai.
so that is for them to say. It is for them to say. Once they.
Not for me to say. But Mr. KM Mohanta, Learned Council appealing for the petitioner. Also heard for BTC. Mr. So-and-so Learned Council appealing for the after Mr. Mohanto has impressed upon this court that
The stay order operating.
the document at annexure A to the writ petition clearly demonstrates that the petitioner had joined his services in the year 2016.
Yes.
And he had joined the present school to which the UDICE is relatable in the year 1/1/2018. He has also referred to another document. Which was that page 119? Page 1, another document dated 26/12/2015 to impress that the petitioner had been asked to join the UN Academy Novosti on or before 1/1/2016. The Learned Council for the BTC has prayed for some time
Anytime next week, Your Lordship.
to do what?
Lordship, the instructions were sought for as per order date 21.
To produce the instructions that were sought for from the by the order dated 21/2026. This court observes that the petitioner was, where was that letter? 119, huh? That the petitioner was offered appointment in the UN Academy Novosti on 26/12/2015, and the UDICE of the same school records that he had joined the school on 1/1/2018 and had been in service from 1/1/2016. Cut out that last line. List again on. You take it like this. This court notices that the UDICE relied upon by the Learned Council for the petitioner shows that he had joined services in 1/1/16 and was also serving in the school on 1/1/2018. Full stop. With the UDICE having been produced, it is a submission of the Learned Council for the petitioner that. What is your
have
challenge?
All the 6 documents we have, Lordship. The question is, Lordship, if you kindly repeat one thing, we have all the 6 documents from A, B, C, D, A till E. We have all the documents. F, they come up and say the verification was done. In F, the state respondent said that you don't have the UDICE of 17/18. That's why we cannot allow. Other documents from A to E we have. My question is the UDICE record. Here it was said that only as UDICE record. So from 18/19, if we take it, then our date of joining in the first service is reflected there. But other A, B, C, D, and E we fulfill.
Full stop. The Learned Council for the petitioner submits that the UDICE would reflect that they had joined services on 1/1/2016. And therefore they were in service at the particular relevant period of time. Full stop. List again on, when do you want it?
Be on the third of Feb.
Not third, fourth.
Yeah, education department has got nothing to say in this. Why do you need the UDAS for 17? Huh? No, whatever orders we passed or with regard to the BTC authority, will it not affect the education department? Because we will say either that this is correct or this is not. If we hold that asking for the particular UDAS is not correct for the BTC, same will apply to you also. No, we are not on that. The demand for the UDAS with their name in the year 2017-18, whether it is correct or not. If the demand by BTC is not correct, any demand made by you will also not be correct. You are an affected party. The learner council for the respondents also seek some time to file their affidavit. List again on
6th year also.
6th of February. 6th of February 2022.
Interim order may be continued.
Interim order passed earlier restraining appointments. Interim order passed earlier shall continue.
Deeply okay.
The schools are without teachers now.
No, you. With the first recruitment. It's an appointment. First notice, appointment.
Yes. দিয়ক সময় নাই
61.
May I please, your lordship?
Yes.
Lordship, if you have a look at the first order in this matter on 15th of December, the issue that was raised, notice was issued in the case. This is a case of an associate professor and also PhD guide who has been terminated retrospectively. But her termination alone is not being challenged. What she is challenging is that the university is not following UGC and PhD guidelines and various other public laws which they're subject to. Now, the question that was put to us was that whether such a writ petition is maintainable against a private university. And I had addressed this court with about 5 judgments, my lord. And I had also mentioned the relevant paragraphs. And pursuant to that, my senior colleague, she had filed her response on the maintainability alone. So now we are here to finalize regarding the maintainability, and we have filed our rejoinder in the form of an affidavit. And in the last date of hearing on 19th, we had given a written submissions and the cases mentioned therein. Basically, it's a standard process of law.
When did you file your reply?
The reply was filed yesterday.
No. Today they tried to serve a copy on me at around 11:30 AM, which I have refused to accept because the order was very clearly. It had very clearly mentioned that on or before 27/1.
Okay,
I
I
can
can
have a
see.
response to some.
Of course, no, I concede. I concede on that. If I may.
Your reply is not on record.
It's not. If I may, the written submissions that we had given in our last hearing, we are able to address this court based only on that.
Let us have it this way. We'll keep the issue of maintainability open for the time being. Let your reply be here on record.
Okay.
Once we start dictating the order, we'll have to go through some papers. So we'll like to go through what reply you have filed and whatever.
Yeah, absolutely. That was served on me on that day.
Yes.
So if she's
Then we again have to trace that out. At this fag end of the day. Brief written argument is here.
on 19, what at 2:20 PM?
And 30 paragraphs, brief written argument. I understand things have to be explained at times, but at this hour, should we be taking up this or should we be
To address this court in about 1 minute. I want to say 30 seconds, but I'll take 1 minute. If you put it on record, I will just tell you quickly in 1 minute.
No, once we take the objections into, once we take Madam's objection into.
Because she may be convinced. I may have to unconvince you lots.
And then I need
Let us have a convenient date, we'll take it up for orders as early as possible. Give us a convenient date.
Can we have it next week because I'm coming from Delhi, so I have to go.
Next week?
Um, any second of February?
Second কেইটামান হল হয় হা জায়গা আছে 2nd of February 2nd of February
Yes.
when have someone mentioned in the morning so that we can take it up like that. No, we'll not record it in the order, we'll take it up
Deeply appreciated. Thank you.
list again on the 2nd of February as paucity of time has not because due to as paucity of time did not allow the matter to be taken up today for a full hearing.
May I please, my lord? This matter was heard before your lordship. In the meantime, they've changed the council and I have entered.
Okay.
And it's my opportunity to place before your lordship. My lord has heard
this was
regarding the
regarding
matter, the issue. This particular issue was non-complaints of 4748.
Okay.
Apart from the, my lord, one issue was not addressed. So for a disputed fact, whether he was arrested on 7th or on 8th, apart from the my lord,
at the airport, something
at
like
the
that.
airport. And my lord, when he was arrested, allegedly arrested on 8/6/2025 at 9:40 AM at Imphal Airport, my lord. That is what the CBI says. He was never produced before any
court in the
magistrate out there in Imphal. That is, my lord, that is.
Although we do not want to do so, sir, but if you are arguing the matter afresh, if you'd like to make your submissions afresh,
Sir, I'll continue that
we'll
argument because
we'll have to take it up maybe on Friday, 2 days hereafter, if it is convenient for you. Today we would like to take it up, but it's 4:15. By the time you finish, then she finishes again. We'll fix it up for Friday. It will not, since it's a bail matter, bail application, we can take it up on Friday at best. Friday, बहुत আছে নেকি? Huh? Friday কিমান আছে? খুব আছে।
my lord, can it be on 5th? If
5th, yes.
But my humble request would be, my lord, if it comes in the top of the list, because matter.
So that request has to be made on that day. One request made on that day, we can take it up. If the request is made on that day, we will not remember it today. Criminal cases, it is.
And if your lords, if my lord.
No, 5th or 2. Yes, sir.
If my lord, passing that order that it should be in the top of the list, then normally it will come.
No,
Otherwise,
it will come in the list. Just give us a reminder. নহলে এইটো ক্ৰিমিনেল মেটাৰ থাকিলে আগতে মাতি দিব এনেকুৱা বেল টেল থাকিলে আগতে মাতিব নহয় জানো বাকীবিলাকতো বেলটো ইম্পৰ্টেণ্ট আপগ্ৰেড কৰাই দিলে হ'ল জাষ্ট গিভ আছ আ ৰিমাইণ্ডাৰ অন ডেট ডে উইল টেক ইট আপ on 5th list this matter again on 5th 5th কৈছে 5th of February 2026
or maybe can we fix at 2 PM sir then so that
on 5th of February 2026 at the request of the Learned Council for the parties. Since there is paucity of time today, the parties would be at liberty to mention the matter on the 5th for upgradation in the list.
My lord. Obliged, my lord.
Lordship, kindly peruse the order dated 29/1/25, Lordship.
Jovial Kolita, review petition, heard Mr. R. Muzumdar. List before a bench without me. Have you seen? No. The review petition I had appeared.
Lordship, sorry.
Some names are seldom forgotten. Jovial is happy.
Jovial.
That name is seldom forgotten. Yes.
around 60. So we can other activity and propose the report. For the death notice, we have again called for. It is not active.
My lord, if they're considering it, then my lord, if they're considering 16 petitioners, my lord, by the next date, if my lord fixes the next date,
No.
then they can bring up the entire list of the petitioners they are going to consider, my lord.
Mr. So-and-so learned counsel appearing for the Department of Higher Education has submitted that the process is on for consideration of the payment of salary. Arrears salary to 16 of the 28 petitioners, 24 petitioners. And proposals have been received. The proposals for the rest of the eight petitioners have also been called for from the different authorities. Full stop, place this matter again on. It is not going to work. I'll tell you why. You'll try bringing these proposals till February.
Yes.
Then everybody will be happy. Then the financial year goes. Then it will start again in March and May and June. Place this matter again on when? Give us a date.
13 Lolo, 13 February.
13th of February 2026. Allowing Mr. D. Upamanyu to place relevant updated instructions. This has now become like a CD in a bill. Call for updated CDs. Yes.
Lordship, well, but today I'm paying for accommodation.
Have you received the instructions? No.
They have not received, that's why.
You have not received instructions. Why don't we allow them the opportunity to come before this court and sign the affidavit here itself in Guwahati?
I'm paying for one opportunity, Lordship.
Have you seen the order of 17/12/2025? What was it regarding to? Illegal appointments. When?
Lordship will have it on 16th, Lordship, that will be filed.
On 60, list this matter again on 16th of February
No instructions received, I think.
on 16th of February 2026. Since the Learned Counsel for the respondent BTC as respondent number 4 has assured that the affidavit would be filed by such time. In case the affidavit is not filed by not filed as called for by the order dated 17/12/2025, tell us who is to sign the affidavit.
Principal Secretary.
The Director of Education BTC shall remain personally present before this court, along with all the records available with him.
Fine, man. Fine.
It's free.
Highly applicable.
This is an order of 2023 regarding compassionate appointment. The DLC was to, my lord, consider and, my lord, pass an order with regard to the case of the petitioner. My lord, the new respondent I have implemented in the last occasion, my lord. The earlier deputy commissioner, my lord, has demitted office. So, my lord, on, my lord, 19/12/25, my lord, he was implemented, my lord. Steps were taken. Service coming one, no?
Have you taken steps for?
Yes, my lord, taken steps.
Doesn't reflect.
My lord, in the, it was taken, my lord, on 7/1/2026, my lord.
Huh?
No, sorry. Well, it was taken on 7/1, my lord.
7/1 what?
26, my lord. Because
It-
in
it
the
has- it
vacation,
has-
my lord, there was a vacation, my lord.
The Learned Counsel for the petitioner has submitted that although he had taken steps for service of notice on the
Respondent number 3, my lord.
newly implemented respondents, comma,
Respondent 3, my lord.
on the newly implemented respondent number 3, comma, the same is not, you are not taking it on respondent number 4.
No, my lord, there are 3 respondents only, my lord. Abhishek Jain was newly implemented, my lord, district commissioner. 5/4/4.
Amended cost, I don't know, the office note says something about 4, huh? On the newly, on the respondent number 3, However, there is no office note to that effect. Full stop. List this matter again on, you took it on 7th, huh?
Yes, my lord, 7.
So we'll have it on 12th of February or somewhere near that.
My lord.
Not 12th of February, we'll have it on 16th of February 2026. Full stop. Registry to indicate the service report in the office note. Petitioner would also be at liberty to file the postal, what do you do? Leave it na lagi. If you can file it, you let us know by an affidavit or something.
Because my lord, it's the, the registry has gone, my lord, so we will not be able to.
Speed post. They give you the speed post number, you can find out.
If they give, I can.
If you find it, it will be easier for us. You are appearing for respondent number 2.
Okay, go ahead.
Non-compliance of order dated 34/2024.
What was the order?
Lordship order is at page 12. Sorry. Operative part is at page 32, Lordship. Lordship, may I read, Lordship? In view of the point number 43, Lordship, in view of the interference made by this court with the order dated 4/3/2022 and communication dated so and so, the petitioner are hereby directed to be reinstated in their respective service against the post as indicated in their cases. In the order dated so and so, the Director Elementary Education Assam is directed to release the petitioners their salaries in arrears with effect from August 2021 till the date of their such reinstatement in service, and thereafter to release them their current salaries, Lordship. So reinstatement have been done, Lordship, but
When was the reinstatement done, sir?
Lordship, I have come to know from my client, but date is actually not.
Reinstatement has come on 17/1/2026.
Lordship.
Once they are reinstated,
Lordship.
then sometime in September 2026, the salary bills will be made.
Lordship, but they are not getting salary from 2020.
Now we are not closing this.
Lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. N.J. Khatoniya learned counsel appearing for the respondent number. For all the respondents. Mr. Khatoniya, learned counsel has produced an order dated 17/1/2026 by which the petitioners have been reinstated in their service. And submitted there is part compliance of the orders passed by this court, full stop. He prays for some time to have the salaries he prays for some time to comply, to be granted to the respondents to comply with the order completely. Completely, so far it relates to the payment of arrears salary, full stop. List again on date 4 weeks. 23rd of March, no, February. March, 23rd of March, 2026. Lordship.
56.
It is, sir.
There's a direction.
Yes, sir.
There was a direction to pay the pension to the petitioner, my lord. In fact, the second wife was getting the pension. Then she approached this honorable court, the petitioner approached this honorable court, and there was a direction to pay the pension to the petitioner. Now, my lord, what I've been informed is that PPO has already been issued, my lord, to the treasury officer. Now, therefore, my lord, the treasury officer's rule becomes important, my lord. Otherwise,
if the PPO has been issued, there has been compliance on the part of the respondents. We'll keep it, we'll say non-appears for the contenders on call. Non-appears for the respondents on call. Mr. M. Datta is appearing. List this matter again after. No, we'll have it sometime later. When can we have it? End of February.
Well,
so that by that time possibly the pension will flow.
If that is complied.
List this matter again on 27th of February 2026. Yes, sir.
Lordship, the service report awaited, Lordship, as per office note
Lordship may allow to take dusty service, Lordship.
Why? In contempt, dusty. No. List again on 5th of, no, everyone who's 12th of February 2026, awaiting service report on the sole respondent. What was the order passed? Speaking order.
40th to 15.
Your Lordship will take up the first This is for withdrawal of the name of the few petitioners from the writ petitions. In item number 48, Your Lordship, one of the petitioner,
We have IA number
3741.
3741.
Yes,
of
Your Lordship.
2025.
In 3741, Your Lordship, the petitioner number 1 will like to withdraw his name from
From
the writ petition.
From the writ petition.
There are several petitioners. He wants to withdraw his name.
But then if we allow the petitioner number 1 to withdraw, would not someone else be required to be, who has filed the affidavit in the writ petition?
No,
If the
pleadings are
petitioner
already-
withdraws, if the petitioner withdraws, the affidavit,
No, one of the petitioner has withdrawn.
who has filed the affidavit in the writ petition is what we are asking you.
Your Lordship.
In the writ petition,
Huh.
who has filed the affidavit supporting the writ petition?
That I have to check.
Yes, please check.
Yes, Your Lord.
Yes, so.
I have the copy.
In connection with 8846. This is in connection with 8846, sir.
Yes, Your Lord.
This is the same person. The moment we allow him to withdraw, the affidavit goes. Because he had been authorized by all the other persons to swear the affidavit.
Yes, Your Lordship is right, Your Lordship.
When he runs away from the case, everybody has to run away. List this matter again on
Yes, Your Lordship. He has filed it.
on 3rd of
He has filed it.
February, allowing the learned counsel for the petitioner to have his instructions. We are not saying why. Just keep it. Yes.
Item 51.
My lord, this is regarding non-payment of pension even after service of 27 years. So there is delay in filing the review petition and 30 days delay. So that may kindly be condoned and main review petition may be fixed for admission hearing.
Who are the respondents?
Government as well as BTC.
This is an application filed for condonation of 30 days of delay in preferring the connected review petition, full stop. The
Reasons
issue
are
notice,
2, 3.
issue notice. Yes, Mr. Dhar, you are appealing for
Appearing for
1345
PWD matter. Basically,
3,
3,
4, 5,
4 matter.
3 and 4. You are appearing for respondent number 6. Why not for respondent number 1?
Respondent number 1, public pension, the pension matter.
And who is 6? Director of pension.
No, 6 is accountant general matter.
7 is accountant general.
Then my lord, here our petition is wrong.
What?
Petition.
List this matter again on the 6th of 6th of
7 is
February.
AG.
Huh?
7 is AG.
So copy service 6.
List this matter again on The second,
Director mentioned.
6th of February, huh? Scroll order. 6th of February 2026, allowing Mr. Enu Mahmood, Learned Counsel, appealing for the petitioner to serve corrected copies of the IA upon the state upon the councils for the state respondents. Serve it to everyone. Come back. Payment made. Receive payment.
No, your lordship, according to the last, it was told to find the current status of the payment. According to the last order, your lordship.
List again on 10th of February 2026, allowing the respondents to put up the updated status of the payment.
63.
Secondary education, Mr. Khatonian, are you here? Affidavit. None appears for the petitioner on call. Mr. N.J. Khatonian, Learned Counsel, appearing for the respondents, has prayed for a short accommodation. List again on 20th. 28th, 27th of February 2026. Keta thakil?
64.
Keta asil?
Affidavit file কৰিছে নেকি আজি?
An affidavit has been filed today on behalf of the respondent number 1. List this matter again on
8th
8th
February.
8th February. So
No, madam, already the person is going to be retired on 31st of January. And nothing will left out. Of course, this is regarding arrear salary. The honorable.
area salary, we can have it as 8th of February you wanted, sir. Okay, 8th of February. Sir, only you would be here in court on the 8th of February. 9th ko hi thok, 9th ko hi thok. 9th ko hi thok.
So,
Huh? Yes. 65?
Can it be 9?
It is, I have made it 9th.
I'm sorry.
Yes?
1 and 4 lots.
Ah.
Lordship, as per office note, service has completed, Lordship. Matter may come up for admission, Lordship.
Why is there no order passed in this case? Court order black code. Oh, I see. List this matter again on when?
After February 13, Lordship.
18 of February 2026, by which time the respondents would be at liberty to file their response.
66.
Yes.
In terms, as per the office note dated 27/1/2016.
We don't have the time, tell us.
Lordship, service complete. Lordship.
Office note reflects that the service is complete.
Postal is as per postal.
Service is complete as per postal receipt. Mr. So-and-so appears for the respondent number for the secondary education department, higher education department. List again on?
Lordship, because the petitioner was suspended in the year 2017, Lordship. He was subsequently acquitted on January, Lordship, this year.
This year?
Yes, yes.
So you filed the case this year?
He is not reinstated, Lordship. Till date, he is not reinstated.
This year or last year?
This year.
He was acquitted when?
January, Lordship.
January when? 2026?
Yeah. 25, Lordship.
Then how can it be this year?
25, Lordship.
How can it be this year?
Now.
List again on? Again, 17, 18, 19th of February?
For admission hearing. Lordship.
For admission hearing. Okay.
Perhaps due to paucity of time today, it is not possible.
Due to, it has been stated by the Learned Counsel for the petitioner that due to paucity of time, due to paucity of time, the matter could not be taken up today. List again on?
Can it be, no, third to Jolly, next week, can it be on 13th, my lord?
13th. This is a Senate school matter.
Sunny school matter.
Huh?
Lordship,
Sainik School matter.
till February.
Fifth will be a difficult matter.
Huh?
12th, my lord.
17th is what we are being suggested, 17th of February.
Or can it
They
be
have,
19th?
they have passed their exam, passed
They're-
out from the school, or they are appearing
No, no,
in
my
the
lord,
examination?
they're appearing for the matriculation. So for these days, I don't want to take them extra tension, my lord. That is why I'm suggesting. 19th, my lord, 19th.
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 It is only when we heard it in the court, some arguments going on. No?
Well. Apply, sir. Deep.
Yes. Okay. Finished. Thank you.